Royal Commission into Defence and Veterans Suicide is now resumed. Please be seated.
Good morning, Mr. Sheptower.
Good morning, Commissioners. Commissioners, this morning's first witness is the Premier of Victoria, the Honourable Daniel Andrews MP. The Premier is already seated in the witness box. May he be sworn in.
Do you, Daniel Andrews, swear by Almighty God that the evidence you shall give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Commissioners, I might just allow the Council for Victoria to announce their appearances.
If it pleases the Commission, I appear with Mr Chiolek for the Honourable Daniel Andrews MP, the Premier of Victoria.
Thank you.
Operator, can you please display the tender list? Commissioners, I tendered the documents in the tender bundle in the manner they are described in the list.
Okay. There's 2 pages. 3, 4. Okay, thank you. They'll be accepted on that basis and allocated the next lot of numbers. Thank you.
Thank you. Commissioners, aside from some introductory matters, there are 3 primary topics I propose to canvass with the Premier this morning. First, the veteran landscape in Victoria and gaps in veteran data provision and collection. Secondly, the relationship between the federal and state government and their agencies in relation to veterans issues in this state. And thirdly, the state's recommendations to this Royal Commission regarding Commonwealth arrangements. I may also canvass some state government initiatives with the Premier, but those questions will likely be asked of Mr Plummer, whose evidence follows the Premier's this morning. Premier, just commencing with some introductory matters, who is the Minister currently responsible for the Veterans Affairs portfolio in Victoria?
The Honourable Natalie Sullivan.
And which government department is responsible to the Minister in relation to Veterans Affairs?
Department of Families, Fairness and Housing.
Just briefly, can you please tell the Commissioners about what I understand to be called the Victorian Veterans Council and its purpose?
The Victorian Veterans Council is established under statute, under the Veterans Act, and has been in operation since we established a veterans portfolio under then Premier Steve Bracks back in 2005-06. Its membership is outlined under that Act, and it brings together both ex-service organisation representatives and others with expertise in the field, and serves as a point of reference and a point of, if you like, well, a point of reference, but also a source of advice and a source of counsel to the government, to the Minister and to others. It also helps in making sure that we are fulfilling all the different obligations we have, both in service delivery, program delivery, but also appropriately commemorating the service and sacrifice of veterans.
And am I correct that the Council completed Victorian veteran sector studies in 2008, 2015 and most recently in 2022?
Yes, you are.
And what's the purpose of those studies and how are they used by the Victorian Government?
It's perhaps best if Mr Plummer takes you through at length those that have already been completed. The current one is under the active consideration of the government at the moment, or soon will be. We've not yet responded to that. It's only from last year. But this gives us an opportunity to take stock, to have a sense of the contemporary landscape across Victoria and to set our priorities accordingly and to, if you like, in a periodic sense, check that the interventions we're making, the programs that we're delivering are having the impact we want them to have. It's a very useful tool for both looking back to what has been achieved, but also setting priorities for the future. And the Cabinet Minister will bring submissions around the most recent study, and we'll have more to say about that at the appropriate time.
You refer to it as a useful tool. Do you think that the model of having an independent statutory body to monitor and advise the Minister for Veterans on issues affecting veterans of Victoria is a good one? And if so, why?
Yes, I do. I think that giving the veteran community not just a hearing, but giving them a standing accountable, formal vehicle to, as you say, provide advice, to provide feedback and input is incredibly important. And I say that for two reasons. One, it's a dynamic environment. Things change, priorities change. The veteran landscape has changed dramatically, particularly when we think about contemporary conflicts in recent times. So it's very, very useful in a practical sense. But I think more than that, Mr. Sheptua, it's also a way in which we can validate and honour and pay respect to the service that our veterans have offered, the sacrifices they've made, not ever forgetting their families as well. And it means that things don't get forgotten, that means things don't slip off the priority list, if you like. The standing nature of this, the statutory nature of this, means that there is always the opportunity and indeed a profound obligation to be checking in, to be updating, to be doing more and doing better. That's what a statutory function does, not as a preference from a minister or a priority set by a government, because ministers change, governments change. This is the law of our state, and I think it's a really appropriate step for us to have taken, and I would commend it to others.
So those are some of the advantages. Are there any disadvantages of that
I don't,
model?
not that I'm briefed on, not that I've seen in my time in this role.
In your view, is a Veterans Affairs portfolio at a state level important, and if so, why?
I think that the welfare of all Victorians and making adequate provision for those in the community who are quite often vulnerable is very, very important. That is a first order issue. And I think that the veteran community has a special place, both in positive terms, in recognising their service and sacrifice, but also in often tragic and very challenging terms. The vulnerability that many in the veteran community experience means that it is, I think, appropriate that we've entered this space. Now, we do, of course, acknowledge that these men and women are previously employees of the Commonwealth, and there is a primacy in terms of the responsibility that the Commonwealth has, but there's a role for us to play. Clearly, that's our view, given that for coming up to 20 years, we've had the portfolio and we've had a series of programs run under that. So yes, I think it is incredibly important in broad terms, but also in more focused terms as well.
Okay, thank you. I'll come back to the most recent sector study later, but I'll now move to discussing the veteran landscape in Victoria and the topic of veteran data. Am I correct in saying that prior to the 2021 national census, there were gaps in Victoria's understanding of its veteran profile?
Yes.
And just pausing there for a moment, what's the difficulty with that gap?
Well, as it stands, I think the answer to your question is yes, there was and there still is. I don't think the most recent census has solved all of those problems. It's given us a more complete de-identified picture of the total number of veterans who call Victoria home, but de-identified is the key here. We don't have a list, their names, addresses, let alone any further details of those members of the veteran community. And on that basis, we find ourselves in a situation where we have to provide broadcast messages to a very, in the scheme of things, to a relatively small group of people. That is the biggest gap from a data point of view, and it serves as a significant barrier to us, not just delivering services, but building trust and building a relationship with people, often those, many of whom are vulnerable. It is a real barrier to us doing more and doing better for a group of people who deserve our best efforts.
I'll come back to the specific data point that you just raised, but just focusing on the census, can I ask, were you surprised by any of the results of the 2021 census?
Obviously, we saw a significant increase in the number of veterans that self-identified via that process. Beyond that, I think probably Mr. Plummer is better able to go through any comparative analysis of the census.
Okay, I'll ask him, but in terms of what you're saying, there was a significant undercount prior to the 2021 census of veterans.
Yes, there was.
Are you then supportive of the census question, which seeks to identify serving defence members and veterans?
Yes, I think it's a useful tool. It serves a real purpose, but I think it would be wrong for us to assume that that was the end of the data issue. I think there are many other opportunities. In fact, I think we're obliged to push for a much more complete picture at an individual level.
And I'm going to come to that in 1 minute, but just finishing the census stuff, are there any other questions that you would like to see asked by the census?
I think we have, and again, Mr. Plummer might be better able to assist you with this. As I understand it, I think we have made representations over time about a number of different issues that might be included in the census. We are fully aware that the census runs to many, many questions, and there are obviously limitations on how many questions can be in that census. But I think we have had a history of making representations to the Commonwealth on that issue. But I must say, I think that de-identified aggregated data has a place, but that's not, certainly from my point of view and the government's point of view, that's not our area of focus when it comes to the data that we need for the future.
Okay, well, let's come to that data. In your response, you say that the provision of accurate data by the Commonwealth is a major improvement that could be made. Can I ask the operator to please display a document that the Commission received yesterday evening from Victoria and is titled Victorian Recommendations to the Royal Commission regarding Commonwealth Arrangements, and to highlight Recommendation 1. Premier, can I please ask you to expand on what you say there, or what's written there, by identifying firstly what veteran data the state presently receives from the Commonwealth and why that data is inadequate for the state's purposes, and secondly, how that data sharing arrangement could be improved, in your opinion?
So, Mr. Sheptool, we currently receive twice per year what are called separation reports, and they provide de-identified data as to those that have left the Australian Defence Force and are living in Victoria. We are provided with some details about those ex-service men and women, but again, it's de-identified data. Now, in our submission and in our responses to the notice to give, we have gone through a number of different data points that would be useful to us. The point I want to make is that de-identified data is useful to get a broad picture, but we are in largely the service delivery business. So if you want to offer people support and help, if you want to make sure people are aware of all the things they are entitled to, and if they're having difficulty navigating a system, the fact that there is advocacy and support, and dare I say it, if you want to try and build between the government and its agencies and that community, that veteran community, a sense of trust, then you need to be able to communicate directly with those veterans, and indeed by extension, their families. When I say service delivery, obviously we have responsibility in the main for health care beyond primary care, particularly mental health. We have responsibility for housing, for training, for, in recent times, a very, very successful veteran employment program that has linked many hundreds, indeed more than 1,000 now, former ADF personnel with jobs in our infrastructure agenda, for instance. We've just made commitments to expand that from the public sector to the private sector as well. So if you want to do that work and provide that level of support, then you need to know who you're dealing with. Now, in the documentation that we provided to you, there are a number of different data sets that we would like. I don't want to speak against our own submissions, but I think the more complex the request, the less likely it is that we will navigate our way through privacy laws and various structures and processes within the federal government. If we simply had the name and address, that would be enough for us to start a discussion and a conversation. That could be an opt-in process. So people, if they don't want that information provided to the Victorian Government and its agencies, then that would be a matter for them. But if that was provided to us, we would be able to, given this relatively small number of people, we wouldn't just be sending emails or letters. We might even be able to build a system where we could have someone personally reach out to those ex-service personnel, thank them for their service, and make sure that they know all the different things that they can come to us for as a veteran and just as a Victorian citizen. Again, I don't want to speak against the longer list of data points, but in my experience, the more complicated the request, the more challenging it'll be to meet. So a starting point would be, from our point of view, names and addresses. So identified data provided as close to real time as possible, and not de-identified data provided twice per year.
So just on the identified data and that really simplistic data, just that sort of basic level of data that you're talking about just name and address, have you sought that data from the Commonwealth?
I think that there's been discussions about data and trying to have the richest and most useful data possible. This is somewhat superseded by events, and if I can I'll try and be brief. Last year at the election, we made a commitment to introduce a Victorian Veterans Card, and I want to thank the federal government and its agencies, departments and others who've worked very closely with us in the rollout of that. So we don't have that data to simply send to people a card. We've worked our way through this. They will go online and register, and they will attest that they are eligible, so they will attest that they are a veteran. And the federal government have committed to then validate and verify after the fact that those people are in fact a veteran. So we will, by that process, finish up with not a complete list of veterans who live in Victoria. It'll be a complete list insofar as those who have applied for the card, but it'll be a big step. So there'll be a gap between card holders and total number of veterans. So we would like that filled with the names and addresses if they so chose. And then from a point of vulnerability, I think those who are leaving the ADF and trying to at least offer, and as best we can, wrap around those people whatever supports we might be able to in that transition period, that data is critical. So that's a long way of saying we're going to, via an initiative that we announced last year and we are delivering this year, finish up with a more complete picture, but updating that, filling in that gap I just spoke to, and the more contemporary data periodically is just as important, arguably even more so.
Yeah, well, in terms of filling that gap, you mentioned that you did have discussions with the Commonwealth. What is the current state of those discussions? And why hasn't that information been provided? What are the barriers?
Again, Mr Plummer will be probably better appraised of the back and forth. They're not discussions, I don't think, that have happened at a ministerial level. I think they've happened probably at a departmental level. There'll be a privacy framework in the Commonwealth that would need to be, you'd need to comply with that. There may simply be, again, I'm not certain whether there'd be any barriers beyond that. It just makes sense to me. And again, it may not be simply providing data. It would be perhaps engaging with the veteran community and those who are leaving the ADF and giving them a pretty proactive opportunity to opt into receiving information. I can only thank federal agencies for their work in assisting us in the rollout of the Victorian Veterans Card. I've not needed to have discussions with any of my counterparts in the federal government, but Mr Plummer could speak to that in more detail. But that's right. It's clunky in that it's an attestation process and then a validation process after that. But it's a workaround that I think will work. Okay. We can do better than this, though.
Well, can I just ask you, just in terms of the opt-in, opt-out, you say opt-in, what about an opt-out system?
That would be, that I think would see, practice and history tells us that would see less people that did not have the information. And again, all it would be, and of course we have privacy frameworks that we have to abide by as well, so this data would all be held securely. And I do appreciate that there would be some former members of the ADF those who perform specialist tasks, for instance, whose identity would need to be, would be treated differently, but that could be curated by the Commonwealth to meet the various obligations they have. But opt in, opt out, as long as we get the information, which then means we can simply make an offer, say in your unique capacity, because of your service and sacrifice and because of all that you've done, you are eligible for the following things. You may need access to many different programs, and we run some of those, and we're here for you. That's all we would be doing. But the power of that is, I think, very, very significant.
You were talking about the veterans card before and how that might improve data. That's great for your understanding of the veterans in this state. However, in terms of greater national consistency and coordination, that card isn't really going to achieve that, will it? It'll just improve data collection in this state, won't it?
Yes, it is a Victorian veterans card, so it'll only be relevant to veterans who live in our state.
And what do you think about something akin to a national veterans card then?
I think that would be one small way in which we could honour the special contribution that veterans have made. This is not just about the ability to identify yourself as a veteran, although there's many ways you could do that. There are a number of modest but I think significant concessions and other benefits that Victorian Veterans Card holders will accrue, and I won't speak for other states and territories, but they are a relatively modest but I think not insignificant way that we can say thank you.
The data that you've been speaking about really focuses on transitioning members. Is that a particular pressure point for veterans that the state has identified?
Yes, I think that it's very clear to us, I don't know that this would be disputed by anybody, that not for all veterans, but for many, at least for a significant cohort within that group, that transition from service into civilian life can be a challenging one. It can be difficult. And when you think about that, you're moving from a very structured, a very kind of binary environment into one that is much more fluid, much less certain. Finding your way can be very challenging. That's in and of itself. If you began that transition, though, with a range of other complexities and challenges because of your service, then that would be an even more acutely vulnerable time. But our experience is that that is a point not just of vulnerability, but it's a point where intervention works, where wrapping services around, building trust, providing support matters. You can make a real difference at that time. So it's not just a negative frame, it's also a really important opportunity.
So thank you. And while we're on the topic of transition, can I ask the operator to please display recommendation 7 of that document which was previously on the screen? Here it's titled Better Transition Supports from Defence and DVA. This is the state's recommendation for better transition supports, Premier. Are you able to expand on that recommendation for the commissioners? And I'm also wondering, I take it from the fact that you've identified better transition supports that you believe that the existing ones are inadequate.
I think that there is many ways in which the supports that are provided to those transitioning out of the ADF and into civilian life can be improved and enhanced. I offer this recommendation and this commentary not to be overly critical. I'll just preface what I'm going to say with that. But the mere fact that the Victorian Government needs, through the Veterans Council and through the Office of Veterans, has to provide advocacy support so that people can navigate a system. So a totally independent level of government is providing support to veterans to navigate another government's systems, speaks volumes for how challenging and often impregnable those systems are.
you talking there about DVA?
Yes. And I'm sure you've heard many more acutely, I'm sure you've heard lived experience and many other representations and submissions to you about this issue. But I think this goes back to a fundamental issue, and that is that for many veterans, there is a sense that they are not believed. There is a sense that they are second-guessed, that agencies that ought to be working for them are operating more like an insurance company, and not an especially good insurance company, than an agency that's there to provide support and care. I'm not sure what the actuarial studies within the DVA show around fraud, around people doing the wrong thing. I would expect those numbers would be almost insignificant. This is a cohort of people who have demonstrated their character by the service that they have undertaken. Why wouldn't you just move to a system where you believe people, where you provisionally approve people, where you are all about them, rather than building systems and processes that are about limiting cost, managing demand, keeping people out and away from the entitlements that they have rightly accrued because of their ill health or because of their service. I think there are many ways that can be improved. And it starts, I think, with believing veterans, and that when they make claims, they are supported, not second-guessed, and not treated as if they were trying to cheat the system. Now, I make this, in my role, Mr Sheptoor, we're all local members first, and I'm blessed to have in my local community and have had an association for more than 20 years with a very big sub-branch of the RSL, and I think the biggest Vietnam Veterans Association sub-branch in the state, down in Noble Park. They have a pension and welfare service there, and so difficult is it to navigate these pension and welfare supports that veterans themselves have spent at least 20 years in my time becoming expert on this system, and then as volunteers spend hundreds, thousands of hours helping their comrades to navigate their way through. I think we can do a lot better than that.
So I suppose in your view you're saying that the DVA system requires a substantial overhaul.
Well, I'm not aware that anyone would try and suggest that it doesn't. Like, clearly it does. In my view, and I'm not offering this as anything other than trying to be constructive. If you don't face up to this, then we'll never ever improve it. But we don't believe veterans. We try and manage their claims away. We do not have the kind of presumptive rights and a system that presumes that they are telling the truth. We have something very different to that. And I think that the navigational difficulty and just the premise of the whole thing, that somehow the claim is not a legitimate claim, is not only fundamentally disrespectful, but I think there's a link too with this broader vulnerability for some, and this sense that you're not being supported and that you're on your own. Like, that's not healthy, that's not safe. So that in itself is a reason to do better. Plus, again, I freely concede I don't have actuarial reports and I don't have compliance reports and things of that nature, but I find it, I would be staggered if people of such character were in any significant number trying to game a system. That's not the nature of the cohort, the group of people that we're talking about.
Thank you, Premier. Can I just return to just one aspect of your statement in terms of transition? And you refer in your response to the importance of a nationally consistent approach to the recognition of skills and qualifications for those members transitioning from the Defence Force. Can you please expand on that for the Commissioners?
This is not dissimilar to, for instance, if you work for a large airline or work for probably the best example, we obviously had a big transition out of our automotive sector some years ago. And there were many people who had essentially, they had a ticket, as it were, they had a qualification inside the gate. So they had developed skills, they had developed competence, more than that, and there was a recognition within the employer, almost as an economic community, of those skills. They weren't all necessarily recognised with a trade certificate and a formal, nationally recognised, their qualification was not necessarily formally recognised beyond that particular workplace. I don't think it's quite as acute when it comes to Australian Defence Force personnel or former ADF personnel, but there is a need, I think, to better align and make sure that, as best we can, there's national consistency so that if you've been performing certain roles, if you've attained certain skills, that we recognise those and that that's as seamless as possible between states. Because that just makes sense. It's efficient. And secondly, if I can be a bit parochial, and I probably shouldn't say this, the Commonwealth Government will be listening, I'm sure, but it seems to me that the Commonwealth Government, through the ADF, invest enormous amounts of money in ADF personnel in training them up. We're then more than pleased to snap them up afterwards and try and provide matching services, whether they come to work on our big infrastructure projects or, as I alluded to earlier on, we're moving to private sector matching as well. And I think we've got close to 1,100. So the last number I had, Mr. Palmer may have a more updated number. There's about 1,100 ex-ADF personnel that we have been able to help secure employment in the public sector. So it's about not cashing in, but it's about making the best use of those skills. But it starts with recognition. If you can't take your ticket around the country, even though you've served your country, then that presents a barrier that we should try and get past.
How can that actually be improved? Is that engagement at a Commonwealth level, or how does
there are a number of what are called mutual recognition arrangements that operate for different trade groups. We've done this before because we have a number of different classes of person that are registered, that are licensed, that are qualified in one jurisdiction, and it's been a long-term project to get the best mutual recognition arrangements across the board, right across the country. So different trade groups, different people, right across the country. If we can do it for trades that have not served, then we can do it for those who've got special and unique qualifications. And look, it doesn't mean that there's necessarily an automatic recognition and a direct equivalence between what you've done in service and what you would do beyond. There might be a need to adapt or update, but again, we should be helping to manage people with that. We should be doing everything we can to see those people transition into employment. We have a labour shortage crisis across our country at the moment, and we'd all be better placed if people could transition more easily from Defence Force service to the private sector, or indeed the public sector.
Thank you for that. I might now move to some matters regarding engagement with the Commonwealth. In your response to this Commission's notice to give, you discuss meetings of the Veterans Wellbeing Task Force, which was previously the Veterans Ministerial Council, and meetings of the Commonwealth State and Territory Committee. Are those the two primary channels by which states and territories formally engage with each other and also the Commonwealth on veterans issues?
Yes.
Now, commencing with the Veterans Wellbeing Task Force, that's the forum by which Commonwealth, State and Territory ministers with responsibility for Veterans Affairs or their representatives meet to discuss veterans issues?
Correct.
And I understand that there have been 2 meetings of that task force since 1 January 2022. Am I correct that those occurred in Darwin in February 2022 and in Melbourne in August 2022?
Yes.
Can I ask the operator to please display the terms of reference for the Veterans Wellbeing Task Force? So, Premier, before moving to your response, and for the benefit of the Commissioners, I'd just like to briefly highlight a few matters in the Task Force terms of reference. The first is that the Task Force was established on the 23rd of October 2020. The second is that the membership of the Task Force consists of the Commonwealth, State and Territory Ministers with responsibility for Veterans Affairs and is chaired by the Commonwealth Minister for Veterans Affairs. The third is that the task force will meet at least once per year and more frequently as needed and as determined by the chair. The fourth, and this is under the heading Operations and Decision Making, is that the task force will make decisions and agree on common principles, but there will be flexibility in implementation to account for each jurisdiction's unique circumstances. The fifth, and this is under the heading Scope of Task Force Responsibility, is that the task force will consider how Commonwealth, state and territory governments can work together to better support the wellbeing of veterans in our community. And finally, under the heading Review and Reporting, that each year the task force should discuss and set priorities for the coming year, informed by discussion at the previous National Federation Reform Council meeting. The task force will report to the NFRC annually on progress and outcomes against its priorities. Operator, can you please now display the Premier's response to this Commission's notice to give and highlight that part of the page under question 3C down to the end of question 3D. And Premier, by reference to your response, I just want to confirm some matters about the task force with you. So starting with what you say directly under question 3C, and that's that the task force meetings are meant to allow jurisdictions to share progress on programs and initiatives delivered to support veterans in their jurisdiction. You go on to say under question 3D that the task force is a way for ministers to meet and discuss issues directly affecting veterans, but that no formal initiatives have resulted from the meetings to date. So does that mean that to date, the focus of the task force has been essentially sharing information, but not focusing on formal initiatives that are actually designed to facilitate a common approach to veterans' issues?
I think that's accurate, yes.
And in your response to question 3C, you say that historically, a significant proportion of the agenda has been for updates on Commonwealth-led initiatives, and other jurisdictions have only had a short opportunities to contribute later in the meeting. You go on to say that more recently, there has been more time for discussion and more time to share ideas on initiatives and programs being run within states and territories. Is there presently a standing agenda item or items for actions or initiatives for decision by the task force?
I don't believe so, no.
What about a standing agenda item which calls for ministers to discuss opportunities for how Commonwealth, state and territory governments can work better together?
I don't believe so.
Is that not a fundamental problem with the task force?
I think it is, and whilst I'm not here to reflect on different governments, I would say I think there's been a marked change in approach in recent times, and I welcome that. I also hasten to add I've not attended these meetings as a First Minister. I attend National Cabinet, but the Minister informs me that things are much more collaborative, and I think the role that states play in this space is much more highly valued under the current chair of that ministerial council than was previously the case. I think that for a long time, the Commonwealth may well have regarded this as a bit of a annoyance, that, you know, this is our responsibility, why are you involved in this space, why are we having to have these meetings? That's my sense of it. I could be wrong in that, but I think that is not an unfair way of describing the Commonwealth Government's attitude to this particular committee. We have a different Commonwealth Government now, or at least we have a different approach, and I think that is good. It has been a kind of show and tell session, and not a lot more than that, and it should be. For instance, the example I can give you is at the most recent meeting in Melbourne, I think that we were pleased, Minister Solomon was pleased, if I've got my sequencing right, it may have been Minister Lean, in fact, was able to take states, territories and the Commonwealth through an update on our employment programs coordinated by former RSL Chief and retired Major General David McLaughlin, and a number of other jurisdictions saw great merit in that approach, including, I think, WA, who were very keen to essentially copy that approach. So it has a role, it has a purpose, but I think it's got potential that is not realised at the moment.
Well, the lack of formal initiatives and formal practical outcomes is unsatisfactory to date, isn't it?
Yes, it is.
When is the next task force meeting scheduled to occur?
I'm afraid I can't tell you that. I'm not certain. My officials will most likely know.
I'll ask Mr. Plummer a few of those questions later this morning. But you don't happen to know why there has not been a task force meeting earlier this year?
No, I don't.
I mentioned before that under its terms of reference, the task force is required to set priorities for each year. Are you aware of the priorities for this 2020 year that were set by the most recent task force meeting in August 2022?
No.
Can I ask this though, would it surprise you to learn that one of those priorities is sharing data about veterans?
It would not surprise me that a relatively simple and quite powerful tool is on an agenda of a committee somewhere instead of being something that we actually get along and do. I would not be surprised by that at all.
And despite it being on that agenda, the provision of veteran data to this state has not improved anyway this year, has it? Aside from the veterans card.
Indeed. Again, and I do want to, if I can, just again make the point that we're grateful for the cooperative way in which the department's engaged with us around the card. It's a workaround, but it's a good outcome. It can be so much better though. But no, I don't think, beyond that, I don't think we've seen any change in relation to the provision of data.
Can I ask about task force improvements? In your response to question 3D, you refer to some improvements that you think might be made of the task force. One of those is strengthening the terms of reference for the task force. Can you please expand on how the terms could be amended to improve the task force for the commissioners?
Well, I think, Mr Sheptua, if quite simply there was an agreement by all governments across the country to come up with a nationally consistent plan to support veterans at times of vulnerability, and well and truly beyond that, if we all signed up to do that, and then we had a process where we tasked our officials, the other group that you referred to earlier, with coming up with a list of things that we all currently do and opportunities that we might seek to pursue, you could, in relatively short order, come up with a national plan for intergovernmental cooperation, whatever you want to call it. We'll probably come up with a better title on that, but you could come up with a minimum set of supports, a minimum set of interventions, a minimum set of expectations that the veteran community and their families could have of all governments, regardless of what part of the country they lived in. That'd be a really simple thing to do. We're all doing different things in this space. I think we're doing perhaps more than any other sub-sovereign government, but there'll be things that other states are doing that we could probably do.
So one of the things that you think is that the terms of reference could be amended to develop a national veterans plan or
Yes.
strategy. And another improvement that you identify is that the Commonwealth could consider sending papers and agendas for comment well ahead of meetings, and states and territories should be given the opportunity to identify and contribute to agenda items. It's pretty basic, isn't it? One would have thought that the state would have been given the opportunity to contribute to agenda items.
You would. I'd say to you though that that's a criticism that could be. Whenever you sit on a committee and you don't chair it, you perhaps always have a view that the papers don't arrive early enough, and you perhaps always have a view that you're not necessarily being perhaps listened to as much as you'd like to. But there is I'm told, again, I don't sit on this particular committee, but I'm told that there could be improvements to that end. That would cost nobody anything. That's a very simple thing.
And that's the responsibility of the Commonwealth Minister, isn't it?
As the chair, yes.
And another improvement that you identify is a regular meeting schedule for the task force meetings. Again, pretty basic.
Yes.
Do you happen to know why there is not presently such a schedule?
No, I'm not certain why that's the case. Well, perhaps I could venture the fact that the group has not been tasked with, for instance, the development of a national plan, means that there's not that accountability, there's not a program of work that calls for a meeting and basically demands that you have an orderly program. The fact that it is an opportunity to come together and simply share ideas and update each other on what we've all done independent of each other, that might explain why it has almost an ad hoc timeline.
Thank you. And finally on this topic, you say that the task force will be improved by stronger national leadership and coordination between jurisdictions. So what is the current problem with the leadership, and how might coordination be improved?
I think the best way I can answer that question is the notion that I just advanced around a national plan. Not states and territories telling the Commonwealth Government how they should spend their money and how they should do their work, but just a collection and a gathering up of all the good things that are happening now across the country, opportunities to do more and do better, and then a formal agreement to move to something like that national standard, if you like. That I think is probably the best way to answer the question. It's not just criticism here. There's an opportunity. There's a way to advance this, and it's a relatively simple thing.
And when you say in your response stronger national leadership, do I understand that to be a reference to the Commonwealth level?
I think that I think there are 2 points to be made there. Obviously, the chair of any committee will have a very big impact on the culture and the work rate and the outcomes of that committee. I think there's been some notable improvement in terms of engagement, not just in this area but across the federal government. I say that as a member of National Cabinet and someone who deals with the national government a lot. But secondly, the delivery of a national plan is national leadership.
Thank you. I might leave the task force there and move to some questions about the Commonwealth, State and Territory Committee meetings. What's the relationship between this committee and the task force?
This is a group of officials who support the work of each of the ministers represented on that ministerial council or task force. So perhaps the best way to understand it is National Cabinet is a meeting of First Ministers, and then the First Secretaries Group is a meeting of heads of Premiers and Prime Minister's departments. That is essentially the parallel to the way this ministerial council or task force works, and then the officials group.
So it's essentially a subcommittee of the task force?
No, I wouldn't say it was a subcommittee. I think what it is, as I understand it, it is the officials who support the work of that task force.
And who attends the meetings on behalf of Victoria?
Mr Plummer, as I understand it.
I'll ask him a few of those questions. Does the committee have the ability to agree formal initiatives, or practically speaking, would it recommend a formal initiative for consideration of the task force?
I'm uncertain about the exact remit of that committee. Again, I've not attended the ministerial one, let alone the departmental one. But if it operates, as I understand it operates, then it would more often than not be tasked with doing things, or could be, and then it would prepare work and bring work back. And the way that normally operates is that sometimes you can have officers' papers and product that is presented as a departmental product, and in other circumstances, a jurisdiction may choose to host or lead an item and bring it back to the bigger group. But it's essentially the Secretariat is the wrong term, but it is the respective bureaucrats to each of the elected members at the task force. So there's a fair bit of back and forth, or at least there could be.
Well, I take it from what you say in your response that the focus of these meetings to date, similar to the task force, has been receiving updates on Commonwealth activities?
That's my understanding, yes.
And again, do you regard that as a failing of the committee?
Well, I would say to you that updates from the Commonwealth are not unimportant, but I think there is potential and indeed obligation for both those groups to do much more.
Well, otherwise, how can it facilitate a common approach to veterans' issues?
Yes, that's right.
So are there any improvements that you think could be made to improve the effectiveness of the committee?
I think Mr Plummer is probably best able to speak to that. I'm not as I said, I don't attend those meetings, but I think the national plan that I spoke to a moment ago might be a pretty good start.
No, thank you. I'll leave that there and ask those questions of Mr. Plummer. Commissioners, I note the time. I don't have too much more with the Premier, but I did ask the Premier whether he had a little bit more time this morning for us before we started, and he said yes. So I might continue, and then I'll give you an opportunity.
Yeah, please go ahead.
Premier, can I just ask your views about a few other matters? Can the operator please display Victoria's recommendations document and highlight recommendation 5? So this is your overarching national veteran strategy that you were discussing before. Can you just expand on this a little bit, and in particular what you mean by a national handover framework?
As I said earlier on, and again others will be able to speak to this in far more personal terms, but if we just for the moment accept that for some, the transition period from service to civilian life is a point of particular vulnerability, together with, in more positive terms, we need to make the best use of the best skills. It seems to me that it should not be acceptable to any of us that if you were leaving the ADF after 5 years, 10 years, 25 years in Melbourne, you would get a completely different response in support than if you were leaving in Sydney or Brisbane or any other part of the country. So this notion of connecting up what we do, what the Commonwealth Government does, so that there's a much more uniform standard, doesn't stop people going beyond that, doesn't stop people doing more. But at the moment, I don't think you can have any confidence that there's anything like a uniform offering. And there's a great opportunity. In fact, I think we're obliged to try and better coordinate what we do, not just when people are moving from one employment to another, or from one phase of their life to another, but in everything that we do. And that simply isn't there now.
Well, can I turn now to another recommendation, which is recommendation 4, which I'll ask the operator to highlight. Something that I'm interested in there is your view about this. The National Cabinet should monitor the implementation of this Royal Commission's recommendations. Why do you regard that ongoing monitoring to be important?
Well, I can only speak from our experience. For instance, we had a Mental Health Royal Commission here a couple of years ago. One of the recommendations of that Royal Commission, and before that the Royal Commission into Family Violence, was an implementation monitor framework. We've been faithful to those recommendations. Beyond that, the Mental Health Royal Commission recommended that a subcommittee of Cabinet be formed and that I chair that. And we've been faithful to that also. It will be for the Commission to work out how to monitor these things. But one simple way would be, rather than in a bundle altogether thicker than this one, simply a one minute noting at National Cabinet of all the work that hopefully has gone on in the preceding 6 months or year. If this was mandated to be a standing deliberative item, a substantive item at National Cabinet, well then you will get the attention of all First Ministers. Almost more importantly, you will get the attention of all First Secretaries. We will all need to be briefed, and we will all need to be able to present. We will all need to be across what's happened in our individual jurisdictions, and that would be a very, very big shift from what happens now, where at best we might note without really considering the work of the task force that you took me to earlier.
And that would really strengthen the accountability for the...
I think so, yes. It's not everything, I'm not overselling it, but the notion that First Ministers are perhaps, again, just to give you an example, are fundamentally required to account for that national strategy that I talked about before, or indeed to account for the implementation of recommendations that this Commission might make. That would be a big step forward.
Thank you. Turning to your recommendation number 2, I'll just wait for that to come up. This is the Commonwealth expanding its non-liability health care scheme for veterans. Could you please briefly outline for the Commissioners why you think that the Commonwealth should do that?
If you spend time when a person needs care, so instead of providing care and support to someone where you accept the premise that they have a need and that you ought to meet that need, and you instead spend that time debating, discussing, fundamentally not believing that person, then you are missing precious days and weeks and months, and in some cases longer. You are missing a precious and unique opportunity to influence outcomes for that person, to change their life and potentially save their life. If you believe people from the start, if there is a presumption in their favour as a person of character and integrity and someone who's served their country, then you will get, I'm absolutely certain, you will get much, much better outcomes. Now, whether it's presumptive rights as such, or a presumption for treatment, or a pre-approval process with validation to come at a later point, ultimately, if someone needs healthcare, they need healthcare. So let's get them that healthcare rather than, again, acting like an insurance company, and often not a very good insurance company.
Thank you. And that goes back to the DVA issues we were discussing earlier. Can I address one more of your recommendations, which is recommendation number 6? Can you please briefly outline if the Commissioners, I'll just wait for that to come up actually, what the veteran payment is and why that recommendation is important?
This is a fairly simple administrative process. So I think it's grossly inefficient where you are eligible for certain concessions, certain benefits by virtue of the Commonwealth Government's status that they give to you. So whether you hold a card, for instance, the notion that you then have to apply for the things that classification entitles you to. So in other words, I'm not sure what the Commonwealth Department these days is called, but the Social Security Department and the Veterans Department are not essentially matching their own data, so that if you are eligible, you automatically get that without having to go through all manner of other processes. Just doesn't make any sense. It's not the number one issue, but if you're getting a veterans payment, then you should, as of right, get all the veterans entitlements that flow from that. And again, we would be able to confer the same benefits in an automatic sense if we had that data as well, and whether that be opt-in or opt-out would be a matter for others.
So once again, it goes back to the data issues we were discussing earlier as well.
Yes. Well, in two ways. We could do this job better if we had the data, but it seems to me that there's a data mismatch even within the Commonwealth Government and its agencies. At least that is the understanding I have. A separate application process doesn't make any sense.
Well, I just have one final question for you, and that's beyond what we've already discussed. Is there any other way that you think that Commonwealth, state and territory collaboration can be improved so that it results in meaningful change and outcomes for veterans and their families?
Well, look, I think there are probably many more detailed ways. Often that's where the real benefits come from. This is a bit unique in some respects. It's such a significant issue, and there are such obvious things we could do. It's not always the case that you have some relatively low cost, relatively uncontroversial, quite obvious things that you can do. I think we do have those opportunities. Mr. Plummer, I'm sure, can speak to some other perhaps more detailed, lower order, but in aggregate, things that would make a difference. But I would say it is my hope, given the unique and much needed nature of this Royal Commission process, a generational opportunity, an opportunity we've not had before. It's not for me to encourage the Commission, but I do look forward to recommendations, and to the extent that we can play a part in implementing those, and to the extent that my evidence today has been helpful, we're pleased to provide it. Any other information that you need, we're more than happy to be as supportive as possible. And I would really commend those points about data, and again I would commend to the Royal Commission, with the greatest of respect, put this on the National Cabinet agenda, and then I think things will be different. I can't guarantee that, but in my experience, things that First Ministers are accountable for and their secretaries are accountable for, invariably are advanced faster and further.
Thank you very much, Premier. Commissioners, I have no further questions for the Premier.
Thank you. Commissioner Brown?
Thank you, Premier. I have a few questions. Firstly, just if you could tell us, and to the extent of your knowledge, with the Victorian Veterans Card, you said that it's being rolled out this year. So where are you at the moment?
With due deference to my colleague, I think that Mr. Plummer will be much better placed to give you an update on that.
Okay, I shall save that question for him. Can you tell me and again, Mr. Plummer may or may not be better placed to answer this, but links between the Victorian government officials, or indeed the Victorian Veterans Council, and DVA and Defence. Are there established links there?
Yes, and obviously in my experience, and Mr. Plummer can add to this, I'm sure, in my experience we have a very productive working relationship with the Victorian-based officials from both, DVA probably in the first instance, and over certainly my time in public life, so more than 20 years, that is a very positive relationship and an important one. I think today is about trying to share ideas about how it might be even more productive.
Yep. So I then just wanted to go to the issue of the data sharing, very important as you've highlighted. When we visited the US earlier in the year, we actually learnt that the Veterans Affairs department over there shares the data of discharging veterans with the states, with the consent of the veteran. They share it with the State Department of Veterans Affairs, who is then able to share it with all other departments that are relevant. For example, if there's a registration concession, they share it with that department, etc. They also are able to share it with local councils, again, with the consent. Would you support that kind of a system?
Yes, I think if you could adopt a system like that, that's essentially what I think we've been talking about today, that system, which I'm sure works well right throughout the United States, and given I would have thought that in our country, compared to the United States, where we more highly value and are far less cynical about the role of government and the role the government has to play in providing services and supports. If they can do it there, I'm pretty sure we can get past any privacy issues if it's opt-in with consent. But it just means we're all able to do more and do better.
I think we heard that the numbers are actually quite high, like in around the 80+% of veterans actually agree to share their data with the states.
And I think, Commissioner, that makes sense. It's principally about the provision of concessions and benefits. Like, it's in everyone's interest to have as much information in front of them as possible. And if they do need help, if they do need support, whatever that might be, or a family member for that matter, then to be part of a system and to be invited into that system rather than having to navigate it just makes sense.
So you've kind of preempted my next question, I think, in part, because one of the issues about consenting or agreeing to share your data is that you need to trust, and veterans, well, some veterans come out with a distrust of government. So, inviting people in a very open and transparent way, I guess, is a way of trying to build trust. But do you have any other thoughts about how that trust with veterans could be established?
I think, Commissioner, if we, again, in our submissions, we've listed a whole range of different data points that might be useful to us. But to your point, and I think I made the point earlier as well about trust and about a relationship that's not just a letter that arrives or an email that arrives. We're talking about relatively small numbers of people. You might be able to actually reach out personally and have a really important discussion with people. I think the less information that we seek, the better, the less complicated this is. Just your name, just your address, any contact number you might have, if you choose to provide that or don't object to that being provided, and then you can provide whatever further information you choose to about your service, about your qualifications, about whether you've secured housing, whether you've secured a job. All of that could be controlled by you. I think that's how you build trust. So we get the bare minimum. So instead of having to do broadcast messages to what is, in the scheme of things, a very small group of people, we'd instead be able to reach out. I think it's the most respectful way to do it too. Rather than expecting people to come to us, we make the effort to go to them in recognition of all that they've done and the sort of people that they are. It's just a respectful way of doing it.
Mm. And can I just ask you about, I was very interested in your comments about, I guess, your experience of how the annual report to National Cabinet currently seems to have been treated, which is a kind of noting report, as opposed to the potential of having it as a standard agenda item for discussion.
Whilst I shouldn't reflect on what happens at National Cabinet, but I don't recall ever having a discussion about veteran-related matters. I stand to be corrected, but I don't know that it's ever necessarily been a substantive agenda item. And if it were, then it was not the subject of a lengthy discussion, or it would have been noting, almost kind of pro forma.
Yes, and I guess that's where I was going, because you and I both know that matters can still be standing agenda items on national ministers' meetings and still just be
taken as read. Absolutely.
How might that be prevented?
I think if you were to, again, these are entirely matters for you, but if you were to recommend, for instance, that there be an accounting at National Cabinet for implementation of recommendations you might make, or a report from, say, an implementation monitor, if that was something that you chose to do, I think there are ways in which you can make it specific enough that it's not just a noting issue. And then, to be honest, we will, as we always do, we will rely on veterans advocates and others to hold us to account. So when the Prime Minister, as the Chair of National Cabinet, does the press conference with all of us First Ministers after the meeting, it'll be part of the communique. It would be part of perhaps questions and answers from journalists. You've elevated it. It doesn't guarantee anything, but it brings it, I think, into a different space.
Yes.
And over time, you'd hope that made a real difference.
Yes. And so, again, in a similar vein, we talked about the CSTC, the officials committee, and you noted that it's the relevant officials who go, but I take it from what you've said and what others have said, that it's actually not the head of the relevant department, it's the head of the veterans unit. So it's a kind of lower level official.
With all due respect to officials of that rank, then I wouldn't. Just speaking from a Victorian point of view, I wouldn't read anything into that in relation to who we send, because the person, if we were to send the secretary of the department of the DFFH secretary, I don't know that would mean you had any greater. In fact, I think the executive director who's in charge of this work is better placed. And I'd be confident that there was a proper communication and feedback and accountability between the executive director and the secretary or deputy secretary for whom he works. It's one of those things. You could have somebody who perhaps has a higher rank but is not actually across the detail and doesn't do the day-to-day work. So that's a balancing act, I suppose.
Yeah, no, I appreciate that. I guess it's just kind of the flow up and down, and how, there's potential for gaps there, and I take on board your points.
Although if I can just very quickly add, it may be even a situation where there is no veterans branch in some states and territories. There might be veterans programs,
I think they all have a Veterans Minister. I'm not sure about at the departmental level. Anyway, that's fine. Just two other questions. The Minister for Defence Personnel and DVA, Commonwealth, launched on the 22nd of August this year the Veterans Transition Strategy. Was there any engagement with the Victorian Government in relation to the development of that strategy?
Not with me at a First Minister level. I'm happy to check for you with my colleague, Minister Solomon, but Mr Plummer may be able to. It would have been through officials, I expect. He may be able to shed light on that.
Okay, I will ask Mr Plummer. Thank you. And just the last question. There was previously a Prime Minister's Advisory Council on Veterans Affairs. I don't think that has continued since the transition to the new committee arrangements after the dissolution of COAG. I could be wrong there. But I just was wondering, in terms of the Victorian Veterans Council, do you know whether there's any connection between the state veteran councils where they exist and any Commonwealth advisory bodies like that?
Not that I'm aware of. That's not to say that they don't exist, but not that I can speak to, no.
Okay, thank you very much, Premier.
Thank you. Commissioner Douglas?
Thanks, Premier, for your evidence. I want to ask about implementation of recommendations at a national level, where we might assume that the recommendations would cover both Commonwealth and state levels of government. One idea we've floated in our interim report is a permanent body to replace us, both to supervise implementation of recommendations and to look at the ongoing problem, because one suspects the problem will continue and may manifest itself in different forms than has previously happened. So we think it'd be a good idea, at least provisionally, to have an eye on it. One reaction to that might be suggested is that existing bodies should be capable of implementing recommendations. And the response to that might be, well, the history of implementation of recommendations in this area doesn't justify that level of confidence. Do you have any views about the desirability of implementing bodies, particularly in areas like this, where there are Commonwealth state shared responsibilities and probably shared responsibilities across a variety of at least Commonwealth departments too?
Certainly I do, Commissioner. Lest anyone think that I've presented here today with a critique on the Commonwealth Government and somehow putting it forward that Victorian delivery of services and administration is perfect. That's not my intention at all. We all have areas where we can do more and do better. To that end, we've had 2 Royal Commissions that are principally about service delivery, family violence first of all, and then mental health afterwards. Implementation monitors were a feature of the recommendations of each of those. If you're asking me my view, I would not leave it to those who need to implement the recommendations to do so without oversight. I think that all the expense, all the time, all the effort, all the anguish that people have been through to tell their stories, I think that ultimately the best thing is to have that safety valve, to have someone there oversighting departments and agencies to make sure that they are faithful to the recommendations you make. That's a simple thing. It doesn't need to be a very large number of people. It can be as efficient as possible. We have implementation monitors for both of those, and they've been a real asset to us in keeping us to account and making sure that not just internally, but we are publicly, they report to the Parliament, we are publicly accountable for progress we've made or not made. It just changes culture, and it means that things are not just a moment in time, but what will always be a journey. So things take time to change, culture particularly. We're accountable and we're all, nothing's gathering dust.
No. You're asked questions about the National Task Force on Veterans Wellbeing and about National Cabinet. It seems to me, and I'd welcome your comment on it, that bodies like that aren't particularly well placed to continually monitor issues like this.
Yes, and I would say to you that if you were to, beyond your interim report, if you were to, say, recommend an implementation monitor type framework, perhaps the best way for me to answer it is, as a First Minister and a member of National Cabinet, I would be deeply grateful to that person to come along and, frankly, very deliberately go through where things were up to, where things had been done that were on track and where there were issues, and call out individual states and the Commonwealth where we could do more. That would be useful, more than useful. That would mean we could all concentrate our efforts.
Thanks.
Thank you, Premier. Look, it's clear to us, and we're happy that you clearly recognise the important role that states and territories play in actually providing help for veterans and employment, housing, health and so on. So I just want to place on the record that typically we've heard from ministers, not premiers. You're actually the first. And the reason I bring that up, apart from thanking you, is that your attendance here not only gives these issues the gravitas they deserve, but that you actually volunteered, if I can use that term, to do so. So we're grateful for that. We hope that commitment and engagement is replicated and continues, obviously, across the country. But forgive me, this will be a little bit long-winded. I'm going to put a premise to you, and then I just want to delve into your thoughts. With that in mind, I'm sure you've been briefed on the sorry state of affairs which caused this Royal Commission to be established. Almost 60 inquiries that preceded us, 750 plus recommendations, and in between 1997 and 2020, at least 1,600 suicides, something like 20 times the number of those who were killed or died on duty. These were significant reports that landed on the desks of Prime Ministers, Ministers, Chiefs of Defence and Secretaries of Departments. And frankly, not much happened. Our dilemma at the moment is, as Commissioner Douglas highlighted, is what we recommend and what we find and what we tell government about what ought to happen when this Royal Commission finishes. As Commissioner Douglas outlined, we are considering an entity that may be created after us that looks a lot like a Royal Commission, but on a permanent, we'll implement our recommendations, oversight our implementations, and then forevermore watch this space, obviously. We, as Commissioner Brown mentioned, we looked at the United States, and frankly, the situation there is chalk and cheese compared to here. You've heard the saying, there's a difference between being in charge and taking charge. The Americans, both at congressional level and at White House level, are engaged, involved, interested, and very much driving the implementation of recommendations from various inquiries, demanding briefs and people giving evidence on oath in various Senate inquiries and so on. It seems to me a whole different world in terms of the engagement, commitment and interest from the political class, which makes things happen. We haven't had that in Australia, and I don't think I'm being harsh. In your considerable experience, what's your advice about changing that?
My best advice or best way to answer that would simply be to go back to the comments I made to Commissioner Douglas earlier. I think a statutory body that is enduring, that has responsibility for monitoring the implementation of each and every one of the recommendations you make, as that's one part of their role. The second part of their role would be to be inquiring and to be truly monitoring not just implementation, but change circumstances, the dynamic, the nature of the sort of contemporary challenges that are faced, all of that. So it's an ongoing thing. It's not just well, there's 500 recommendations and they've all been delivered and tick, we're all done. It needs to be enduring and inquiring. Now, of course, you can write a very lengthy series of amendments to various acts to establish that statutory authority, but who you choose to run it would be a really important thing. That won't be a matter for you, it'll be a matter for the government, but I think that's a big start. If you can have formal, enduring oversight where people are appointed for 5 years or whatever it is, and they've got a really clear function to perform, and they can do that fearlessly, then I think that that'll see more recommendations actually progressed. And if you can structure it appropriately, it would then be a standing place, where families and ex-service personnel, veterans, could come and keep people updated. I think that would be a profound investment in not just making the most of this moment, but hopefully avoiding the need to ever have a Royal Commission like this again.
Thank you, Premier. You've validated a lot of what we're thinking. Thank you. Mr. Fordham, do you have any questions?
No, thank you, Commissioner.
Mr. Wood?
Nothing arising. Thank you, Commissioner.
Thank you. Mr. Sheptour, any matters arising?
Just one very quick question. We were talking before about your recommendation 5, which is the National Veterans Strategy. This state doesn't have an overarching veteran strategy document. So I was just wondering why you then view that a national strategy is a good idea, and what's the difference?
So we have a series of different programs that we run. We have not necessarily collated those into one standalone document. That's perhaps something that we can look at in the future. I would say that the principal reason for that is that we can view, as a service delivery, as a state government, we can view people as veterans, and we should, but they're also patients and students and concession card holders, and we have responsibilities to that group of people in many different ways. There's no shortage of programs that we run, but there's no one single document. That might be something that we should look to, and perhaps all of us will be in a better position if there is a national sort of minimum standard. We would all benefit from that because it would help all of us to formalise what we do.
I suppose in one way it'd be almost better to have just one national strategy document rather than each individual state having their own, wouldn't it?
It would be, but the absence of a national framework and the fact that, not to be unfair on the Commonwealth, we have entered this space. This was traditionally not a space that we entered, not in a named way. Of course, we provide, to my earlier point about hospital services, for instance, to veterans, but we, obviously back in more than 15 years ago now, we entered this space. So it's not surprising that federal structures don't necessarily recognise and account for that, but that might have been a relevant excuse, if you like, 10 years ago. It probably isn't now. We're all in this space, and we have been for a long time, and we should all just work together and have a common platform so that if you're in, no matter what part of the country you're in, you're getting pretty much the same level of support from the state government. So that and also, just to be fair, it's not a criticism of the Commonwealth. We want to work with the Commonwealth so that we're all making the most of the considerable efforts that we go to.
Thank you, Premier. Commissioners, I have no further questions.
Thank you. Again, Premier, thank you for your time today. Thank you for the preparation you've clearly put into the evidence and for allowing us to go a little bit over time. We very much appreciate it. Thank you.
Well, may the Premier please be released from his summons.
Yes, certainly. You're excused from your summons to appear today, and we'll adjourn for 15 minutes. Thank you.
All rise. The Royal Commission into Defence and Veterans Suicide will now begin. The Royal Commission into Defence and Veterans Suicide is now resumed. Please be seated.
Thank you, Mr. Shepto.
Thank you, Commissioners. Commissioners, the next witness is Mr. Plummer, who is the Executive Director, Grants, Veterans and Youth in the Department of Families, Fairness and Housing, which is the government department responsible for veterans affairs in this state. Mr. Plummer is seated in the box. May he be sworn in or given the affirmation.
Do you, Anthony Plummer, solemnly declare and affirm that the evidence you shall give will be the truth, the whole truth, and nothing but the truth?
I do.
Commissioners, I might just provide an opportunity for the State of Victoria's Council to announce their appearances.
I was just going to ask. Thank you.
Thank you. If it please the Commission, Mr Young with Mr Ayres appearing for Mr Plummer.
Thank you, Mr. Young.
Commissioners, introductory matters aside, there are three broad topics that I propose to canvass this morning. Firstly, some matters regarding state, territory and federal coordination of veterans issues. Secondly, this state's Victorian Veterans Council. And thirdly, some of the services provided to veterans in Victoria. Mr. Plummer, commencing with some introductory matters, you're the Executive Director of Grants, Veterans and Youth within the Department of Families, Fairness and Housing. What are your roles and responsibilities insofar as they relate to veterans issues?
Thank you, Mr. Sheptour. So my roles in regard to veterans issues in this role are very much around providing advice to the Minister for Veterans, as well as working with the Victorian Veterans Council and the Office for Veterans.
And is the Office for Veterans, is that the team within Grants, Veterans and Youth branch in DFFHH that works across the Victorian Government?
That's correct. So the Office for Veterans is a team of 15 people. It includes 1/3 of the staff are veterans themselves, including the Director of the Office.
So I note in your response that you say that, the state says that the Office for Veterans provides coordinated whole of government support for responding to the needs of the Victorian veteran community. Practically speaking, how does the Office achieve that coordinated whole of government support?
Very much about working across a range of different committees that the government has, and also through the cabinet coordination process. So I sit on a number of committees, including the Prevention of Suicide Committee, which is a subcommittee of the Secretary's Board. Similarly, members of the office sit on the Disability Interdepartmental Committee. I chair the Veterans Card Implementation Committee, which involves departmental officials that are all responsible for the various discounts that are afforded under the card. And similarly, the cabinet coordination process, which is an integral part of any new policy development or any new initiative that is proposed. We provide, where it is relevant to veterans, an advice piece which is around how best to support Victoria's veterans and ensure that the program is delivered in such a way as to improve outcomes for veterans.
And do you raise issues at those veterans at that committee level?
We do.
And how does it then move from, let's say, raising an issue at a committee level in a department, perhaps that you don't sit in, to policy?
Well, if I can use the example perhaps of the Mental Health and Suicide Prevention Committee, the purpose of that committee is very much around overseeing the implementation of the Victorian Royal Commission into mental health and the mental health system. And so we have raised through that the value of having, say, for example, lived experience of veterans as part of the implementation model. And that has been something that the committee has been receptive to, and something that is now a part of the rollout of the response to the Royal Commission.
And I understand that DFFH provides advice to the Minister for Veterans, but aside from its advisory role, what are the other primary roles and functions of DFFH insofar as they relate to veterans? Is it, for example, service delivery or...?
Yeah, I mean, certainly service delivery with respect to things like the Veterans Card, but also a number of programs. I'm thinking here of the Shrine of Remembrance. We oversight the outcomes at the shrine. Also, the Public Sector Veterans Employment Strategy that the Premier mentioned earlier. The Premier's Spirit of Anzac Prize, which is a prize for students in years 9 to 12 to better understand Australia's war history. And in this case, they will be travelling overseas as part of that prize. So there's a significant amount of work to do with that. We also oversee the 4 grants programs that are within the portfolio. 2 of those are within the purview of the council, the Veterans Council, and 2 of the other ones, the capital works and restoring community war memorials, the responsibility of the Minister for Veterans. So we provide all of the secretariat function that delivers those grants.
I'll come back to that secretariat function in a moment. There were some matters this morning that the Premier identified that you might be better placed to answer or in some ways expand on or add to. I might just ask you about some of those. One of those concerns the Victorians Veterans Council, and that's completed veteran sector studies most recently in 2022. Can I ask you, what is the purpose of those studies and how are they actually used by the Victorian government?
So the studies are conducted on a periodic basis and provide us with a snapshot in time of any emerging issues or opportunities in the sector. The most recent one spoke to an opportunity around expanding on the Veterans Council's role in terms of stewardship, and also talking about the challenges around the different types of definition for veterans under various pieces of legislation at the state and territory level. So they provide advice to government that is amongst many other pieces of advice that we glean, whether it's through engagement by the Office for Veterans, via the Council, via the Minister themselves, which then forms part of the government's program delivery and exploring opportunities for new initiatives.
Well, how important are these studies to the development of state policies and initiatives for veterans in this state?
I think they're an important input, but they're one of many. I wouldn't suggest that they are the entirety of the state's basis on which it makes decisions around policy.
So, am I correct that the Victorian government is still considering the 2022 report?
Yeah, they are, and I think it's probably worth talking about some context there. So the report was provided to the council because the council themselves commissioned the study, and they took some time to deliberate upon and consider the recommendations therein, and then provided the report to the minister in December. We should remember that there was a Victorian election in November of last year, so as with all elections, there's a caretaker period that occurs in the lead up to and after an election, and so this report was provided, shortly after that period when the minister was just new to the portfolio. So I would expect a response in due course. The other piece of context I think that's relevant is that the 2015 sector study, the time between that report having been provided to government and then a response being provided by government was a year. So we're still certainly well within that window.
Can I just ask, just firstly, so I understood the report to be dated July 2022, but you're saying that it wasn't provided to the government
So
December
you're correct, the report was dated July. It was provided to the Veterans Council at that time. The council then took some time to consider the report and then subsequently provided it to the minister.
Did it take 6 months to consider did it change the report? It's the Victorian Veterans Council report, isn't it?
It is. They commissioned a consultant to undertake the report and then provided their own overlay of advice on top of that report.
So they got the consultant's report in
Yep.
about mid-year. It took about 6 months to
Correct.
then finalise and provide it to the government.
And to be fair, the council are not full-time. They're sessional members who had probably 2 meetings in that intervening period, and I think that was a reasonable amount of time for them to consider it.
So what are the next steps, and when will the state's consideration of that report be complete?
So the next step is for government to formulate its position and then to release a response to the report, and the timing of that is a matter for government.
So you have no indication
No.
when that might be? That's up to the minister?
Yeah.
One of the recommendations in the report is that the Victorian Veterans Council should target the accessibility and quality of mental health and suicide prevention support services as a priority area in its outcomes framework and efforts to address service gaps in the Victorian veterans sector. What are the issues that this recommendation is designed to address?
So I think, like many of the recommendations in the report, they're very much around issues that I think it's fair to say are not a surprise to the Office for Veterans or probably to the Minister, because they're matters that have been raised through a number of different avenues. In terms of what the next steps might be for responding to that, that's really going to be a matter for government, and given the mental health portfolio is not my portfolio, it's difficult for me to expand a lot on what that might look like, but we would obviously consult with that portfolio to make sure that the implementation made sense in the context of the broader reforms that are happening in that area.
So in terms of implementing that recommendation, it actually does require coordinated whole of government
Absolutely.
support.
Yeah.
And that's why it would potentially take time, I suppose. As well.
That's why any recommendation in the veterans portfolio, unless it is something that we can directly achieve or affect an outcome through the Office for Veterans, is going to require that coordination function.
Well, can I ask, what were the key learnings or takeaways from the 2022 sector study?
Yeah, I started to touch on them earlier, including the recommendation that Council provide that stewardship function across the sector, and I think it's probably worth noting and speaks to that issue that I was talking about earlier, where this is one of many inputs, and the findings in the report perhaps weren't a huge surprise. In August of last year, the Veterans Council convened an ESO, an ex-service organisation summit, which brought together 250 people from the ESO community. It was the largest gathering of its kind, and as I understand it, certainly the first in Victoria and potentially the first in Australia of its kind. And that was very much, I think, one way that the Veterans Council can improve that stewardship function that is referenced in the sector study.
I suppose one of the things is, you're saying it's not surprising, but you've had the report for 8 months, but given the fact that it wasn't surprising, it means the issues were known prior to that. Does that make the delay a little bit worse?
I think there is still a need to provide that coordinated response, I think I don't see this as being a particular delay. I think it's in keeping with the timing of previous reports.
That doesn't make it good. That just means it's consistent with perhaps poor timing in the past.
I think these things are complicated. Any of the issues that are raised in the report are not things that can be solved by any single part of government unilaterally. They require a coordinated response, and they require a considered and appropriate amount of time to ensure that the response makes sense in the context of broader reforms that are already underway.
Just in terms of the issue, or turning to the issue expressly of veteran suicide and suicidality, does the state receive advice about suicide monitoring data, for example, from AIHW?
Through the reports that AIHW provide, we receive those, yes.
Not independently of that?
I don't know.
And does the state provide any funding or services specifically directed to the issue of suicide prevention? For veteran suicide prevention, I should say.
Certainly towards suicide prevention through the mental health response that I touched on earlier, and the nuance that we have engendered in that response through our coordination work with that portfolio. But I guess I'll leave it there.
Can I, just in terms of the ESO summit, you mentioned that before. As part of the Veterans Council's functions, I understand that it hosted that summit. Is that correct?
Correct.
So how did that summit come about? Like, why did it come about?
The summit came about as a result, I think, of a recognition that the landscape of ESOs everywhere in the country, and no different in Victoria, is complex. And there was a study in 2015 that found some 700 ESOs in Victoria alone. And so this was born out of, the summit was born out of a conversation between the then Minister, the Honourable Sean Lean, and the Chair of the Veterans Council, who identified that as an issue and saw this as an opportunity to potentially explore some opportunities for collaboration within the sector, within the ESO sector.
Well, you mentioned the ESO landscape in Victoria. Can I ask you, how would you describe that landscape? We've heard in this Royal Commission, for example, that there has been poor engagement, collaboration, fractured relationships. How would you describe the ESO landscape in Victoria?
I think it's a rich and complex landscape. There are a range of small volunteer-run organisations. There are some, professional organisations that are much larger and therefore attract a larger proportion of both state and public funding through donations and so forth. That can lead to some tensions between organisations, and that's, I don't think, unique to the veterans sector. It's a challenge in any non-government sector, and that's part of the genesis of the summit, to bring together as many people as we can to talk about opportunities for efficiency and for collaboration, because by nature of having 700 organisations, all of whom are ultimately about supporting veterans, there can be duplication, and maybe there are ways to do things that achieve better outcomes for veterans in the end.
Can I ask about the veteran wellbeing hubs that were established in Wodonga and Geelong? Was the state consulted about the location of those hubs?
No.
Would you like to have been consulted about that location, and if so, why?
I think, as we may come to later, we're very much, and the Premier has spoken to this, wanting to achieve the best outcomes for veterans. And we have a degree of knowledge as a state government engaging and providing services to veterans that perhaps the Commonwealth doesn't have visibility of, and we can help shape programs. And this is one significant investment in the veterans sector, and therefore, in terms of achieving better outcomes for veterans, it's useful for the state to be involved in the design.
Do you think there were better locations for the hubs, or?
I think there are. I don't think they're bad locations. I think there are other locations that could also be considered. We could consider Gippsland, for example, or Bendigo, but Wodonga and Geelong are also excellent locations.
So, what services are being provided from those hubs?
Well, the hubs themselves are run by the Commonwealth in partnership with the RSL. And as I understand it, they're providing things like compensation, advocacy, helping people navigate the complex DVA system, providing wellbeing supports, financial assistance and so forth.
So is RSL providing support, or are they RSLs?
The RSL are operating the hubs themselves, as I understand it, and are doing as they do in other, I don't think they're RSL clubs per se, but they're certainly involved in the operation of the hub.
I take it that the state doesn't provide any services from those hubs? And it doesn't fund any services from those hubs?
Well, we do fund RSL for a range of different matters, but not specifically for the hubs.
Do you have any view on the success of that centre in terms of supporting and engaging veterans?
I don't have a firm view.
Are you collecting data on the veteran cohort that's engaging with the centres?
No.
Can I ask a little bit more about the veteran landscape in Victoria? And these are some matters that the Premier touched on this morning. Specifically, I was wondering from you, what did the 2021 census results reveal about the veteran community in Victoria?
I think the most profound thing that we learned through the release of that information was the number of veterans that are here. I mean, previously we had no way of knowing. We didn't have the veterans card at that stage. We didn't have any other way other than ESOs telling us that they had so many members, and we had Department of Veterans Affairs saying that they had this many white and gold card holders, which was around 40,000 mark in round figures. But then as a result of the census, all of a sudden we knew that there were more than 105,000 veterans in the state. So it's certainly expanded our understanding of who's here.
So was that data surprising to you?
Yeah, I think it was, yeah.
So is it fair to say that the 2021 census was critical to the state's understanding of its veteran cohort?
I think it's certainly one useful input. It doesn't necessarily provide us with the detail of where and what services people might need, but it certainly gives us a quantum of the cohort.
I asked the Premier this morning about whether there are any other questions that he would like to be asked by the census, and he said that he understood that Victoria had made representations to the Commonwealth about potentially some of those questions. Are you able to expand on that?
Yeah, I understand that we have sought through other portfolios some specific questions about people's LGBTIQ plus status, for example, or other information. But specifically, I think for the Veterans portfolio, the piece that would be of use for us is to be able to filter the data by LGA and by postcode. Because as the Premier outlined earlier, we now have created a parallel system to collect the information about where veterans are, rather than being able to get it from the high-level census data that's provided or the transition data that comes out of the DVA.
I understood from one of the things in your response that the year of discharge might have been something that you're interested in. Is that the case? And if so, why?
That's really important, I think, because as we heard from the Premier and as this Commission's heard previously, transition is potentially a difficult time in veterans' lives, and if we can engage at the earliest opportunity and provide support, then that would be advantageous for both an efficiency point of view but also for veterans themselves. But I guess where I'm going with this is I wouldn't necessarily say that the census is what we would look to as being our only data source. Department of Defence trains and works with veterans in some cases for many years. The Department of Veterans Affairs then supports them after transition. But I would have thought when we're talking about veterans, they are best placed to provide the information about veterans rather than trying to seek it through the census and seeking additional information there. But that's not to say that it's not a useful way of validating that data and getting more detail.
But you think with the provision of better data from Defence and DVA potentially would ameliorate the necessity to have additional questions in the census, provided that could occur?
It could, but it's also useful to have a point of validation.
I'm going to ask you some questions about the Commonwealth State and Territory Committee meetings, but just before I do that, can I just ask some questions about Victoria?
Sure.
In the Premier's response, he says that the Victorian Government recognises veterans as a distinct group with unique needs. Are you able to expand on that?
Is this in relation to the CSTC? Or?
No, sorry, right. I should say it's divorced from the CTSC. Right. It's just simply a motherhood statement that he began with. Is that something that you're able to comment on? And if it's not, it's not.
So the comment being that veterans are a distinct cohort?
Well, that the Victorian Government recognises veterans as a distinct group with unique needs.
Yeah, and I think the reason that the Victorian government suite of services includes things like an employment program, includes things like the commemorative activities that we undertake, and also includes the work that we do with the Veterans Council indicates that there is a specific set of services that the state provides in recognition of veterans as a distinct cohort.
Well, you mentioned employment and a specific set of services. Just stepping back from that, what do you consider to be the primary challenges faced by veterans in Victoria?
I mean, it really depends on the individual. Everybody's different, but there are some common themes that emerge, including employment, because if you have a job, then it's much easier then to avoid becoming homeless. It's easier then to avoid any potential adverse mental health outcomes, and so on and so forth. So it's very much a foundational piece that can help set people up for a better life.
So employment's one of the challenges. Is that employment immediately post-transition?
Yeah, we don't restrict it to that, obviously, but certainly that is a period when it can be challenging because people may have been in the Defence Force for many years, and then it's a pretty significant change to move into a civilian context and to transpose the skills and experience that they've gained into that new world.
What about things like access to mental health services in Victoria by veterans?
Certainly something that we are aware of and something that we work on. There is the Ward 17 at the Heidelberg Repatriation Centre that provides services to veterans and other people who have experienced trauma. But I don't have a lot of detail about the broader mental health system and how that works, given that my portfolio is specifically around veterans.
Can I ask you one more question about this before we go to the committee meetings? What do you see as the primary challenges for the delivery of services to veterans in Victoria?
Well, in terms of, I think the primary challenge is knowing who they are, where they are, what they need, and how best to deliver it to them. And at the moment, we need to rely on people either self-reporting or presenting and indicating that they are veterans and that they need help, rather than any sort of more strategic approach.
So I'll move to the task force and committee meetings. Am I correct that DFHH provides formal advice and support to the Minister prior to task force meetings?
Provides all advice?
Formal advice.
Formal advice. Yes, we provide a briefing in advance of the meetings.
So, practically speaking, does it base that advice on the discussions which occurred at the Commonwealth, State and Territory Committee meetings, or does it draw from other sources?
I think certainly one of the inputs is the CSTC, but it's certainly broader inputs because the nature of the discussions are about matters that may or may not have been covered as part of the CSTC.
Do you know when the next task force meeting is?
I understand that when CSTC last met on the 22nd of August, there was a verbal discussion about a meeting to be held on the 6th of October, but we have yet to receive the formal correspondence.
Well, I'll come to that meeting in a moment, but how many committee meetings have taken place over the last 18 months?
The CSTC met twice in 2021 and again twice in 2022. So for the last 18 months, that's 3 meetings.
And who's responsible for calling these meetings?
The chair of the committee, which is the secretary of DVA.
And who sets the committee meeting agenda?
The chair.
And are states and territories provided with any opportunity to contribute to that agenda?
Building on what the Premier said earlier, historically that has not been the practice for states and territories to be encouraged to do so, but the new terms of reference that was actually discussed on the 22nd of August does include a specific line that says states and territories are encouraged to suggest agenda items. That's a new development and a pleasing one.
Okay. Well, the meeting was last week. Did you have an opportunity to contribute to?
So that at that meeting, the new terms of reference was discussed, and it was a draft terms of reference that it will be considered at this next meeting of the ministers on the 6th of October.
I see.
Yeah.
So the process will be, when you said August, I thought you meant last
No,
August.
pardon me, last week.
Last week's meeting, yes, okay. And so is that that's a formal recommendation that's been made by the committee to the task force, has it?
So a draft terms of reference for the Ministers' Committee was discussed at the CSTC.
The terms of reference relating to the committee meetings itself?
To the Ministers' meetings.
Oh, so how did you want to, I see, you wanted to change the task force terms of reference to include specific provision for agenda items to be included.
Yeah. And in fact, that's what the Commonwealth tabled as part of their new terms of reference. So it was at their suggestion, which is excellent.
But I suppose that's a change that could also be made at the committee level.
Yes.
Did you speak about that?
It wasn't discussed to my knowledge, but the Director of the Office for Veterans is the person that attends the officials meeting.
So the meeting was last week. Am I correct that you've received a detailed brief about that meeting?
Yes.
Now, actually, I should just confirm, you don't attend those meetings, do you? Who attends on behalf of the state of Victoria?
The Director of the Office for Veterans.
And can you please walk the commissioners through last week's meeting, including the matters that were raised?
So there were a number of items for information. The Commonwealth provided an update on the recruitment process into Department of Veterans Affairs to respond to compensation payments, and indicated that some 500 staff had been recruited since October. There was some discussion about providing options to veterans around advocacy compensation lawyers, discussions about IT systems and using the NDIS as a potential model for the IT system within DVA. There was talk about Department of Veterans Affairs improving collaboration with the Joint Transition Authority. There was an item around sexual misconduct prevention and response, talking about 24/7 support services for victims of misconduct. And there was also a discussion about suicide postvention and state and territory approaches to dealing with that, and the National Transition Strategy, which was actually launched on the same day that it was discussed at CSTC.
And what matters did Victoria raise at that meeting?
So that was the first meeting where this new kind of opportunity for states to raise matters, but Victoria talked about its work in suicide postvention and its aspiration, I think, to have been involved in the National Transition Strategies development, which had been released on the same day.
Okay, so that discussion's occurred.
Yes.
The issues that you raised before were discussed. How will that discussion now translate or influence the task force meeting? How is it going to move from the committee level to the task force meeting in October?
So ideally, there would be a robust governance and reporting structure that exists between the two committees. My experience in the past has been that that's not always the case. Both committees will in parallel discuss similar issues, but in terms of there being a mechanism to update on progress and outcomes and hold committees and officials to account on progress, I think there is an opportunity to build on that.
Yeah, I suppose my concern is that if you don't get to the end of these committee meetings and actually agree on a set of recommendations or agree that this will be items for the next task force agenda or something like that, that it's great to get together and have a chat, but how does it then influence what then happens at that ministerial level?
And I think, in all fairness to our Commonwealth colleagues, the meetings have very much been an information sharing exercise historically, but I am heartened by advice from the Director of the Office, who has indicated to me that there has been a significant shift. At the most recent meeting in particular, there is certainly an appetite for making progress and having more items for decision rather than discussion, including such things as the future agenda for upcoming ministerial meetings.
Okay. In terms of taking that from an idea and translating it into action, what improvements do you think need to be made at the committee level to actually improve the effectiveness of the committee? So is it a change to the terms of reference? What is it that needs to improve? Because again, it's good to come together and talk about these things, but how does it change?
Yeah, I think you're right. I mean, the terms of reference would be the first port of call, and creating a structure whereby there is regular reporting and a mandate for updates on progress on particular initiatives. And I think it goes both ways as well. I think if we're talking about progress on initiatives, there needs to be not just sharing of, well, we're working on a strategy, for example. If the Premier's idea of a national strategy comes to the fore, then we would very much like at the state level to be engaged throughout that process and to help guide and review drafts and provide input and so forth, and then have a regular cadence of tracking of progress against those matters.
Yeah, in one sense, it's almost the committee level that should be setting the agenda for the task force meeting, should it not?
Yeah, I think there's definitely merit in that. Obviously, you know, ministers and others will have views, and that should also play a part. But I think the committee is plays a fundamental part in setting agendas for the task force.
Because otherwise, there's just simply a disconnect, isn't there? You've got the task force level, and you've got the matters they discuss. You've got the committee level matters they discuss, but they don't meet.
I'm not aware of there having been a lot of formal cross-pollination between those two meetings.
Might leave those there because just noting the time and just ask you about some specific things in the state of Victoria. One of those is actually the Anzac Day Proceeds Fund. And as I understand it, that fund's delivered by your department assists the Victorian Veterans Council to deliver that fund. What is that program?
So the Anzac Day Proceeds Fund is an annual grants process which the Victorian Veterans Council determine the recipients of. The guidelines broadly speak to looking for opportunities to improve veterans' welfare, and the recipients of the grants are in large part members of the ex-service community or organisations in that sector. The function of the Office for Veterans is to provide the Secretariat advice in terms of collecting all of the applications and then providing that information to Council to then make a determination as to recipients of that grant.
So how much funding is available?
It varies year on year because the funding is derived under the Anzac Day Act by sporting events on Anzac Day, as well as wagering activities that happen throughout the year, and then that is then provided back to the department for the council to then disperse. But historically, it has been of the order of between $300,000 and $500,000 per annum.
And in terms of making a decision or advising as to who should receive those funds, what criteria governs that?
There's a significant long document which talks about the various criteria for eligibility. I don't know that I could recite it today, but in broad terms, it speaks to activities that are providing benefit to veterans in terms of their welfare and providing support to them when they need it.
Okay. So it's quite broad.
It is, yeah.
So after funds have been dispersed and they're received by, let's say, an ex-service organisation, does the Victorian Government then conduct any formal evaluation of the projects and initiatives funded by the grant program?
It depends on the quantum of the grant. We have in the Department of Families, Fairness and Housing a grants management framework which is designed to be cognisant of the relative impost of significant reporting requirements on small volunteer organisations with the relative risk of the amount of money that is dispersed. So, for example, if the quantum of funding is under $10,000, the reporting requirements are significantly less than they would be for grants that are of a higher order. Most of the grants within the Anzac Day Proceeds Fund would be in the low risk category, and therefore the reporting requirements and the evaluation per se are more modest than they would be otherwise.
And what if that same ESO applied again, for example? Would you then look at how they used last year's?
Yes.
And in terms of the formal evaluation process that you undertake for larger grants, have you done that for last year's?
For the Anzac Day Proceeds Fund, I would need to check what the latest status is.
Okay.
But I know as a general principle, we undertake a review as part of the grants management framework on outcomes of grants as part of the reporting mechanism. And as you put it earlier, if an organisation had been unable to deliver on the thing that they applied for money for, then there would be certainly consideration about whether they would be funded again, and it would be unlikely.
Can I, I'm just noting the time, I'll just ask two quick questions about, we went a little bit over with the Premier this morning. VetSen, can I ask about that? What is it and what need and gap was it responding to?
So VetSen was established as part of the Victorian Government response into the Mental Health Royal Commission. Government provided a package of some $60 million in round figures, including some funding, seed funding, to establish VetSen, which again is run by RSL Victoria and provides a call centre function which is offering a referral and advice service for everything from compensation advocacy to accommodation support to emergency food and bills. Essentially any issue that veterans might present with, the call centre is equipped to respond.
And what gap was it responding to? Or there just wasn't that link?
Well, I think the context, it was responding to a gap in having a place where veterans can go to an organisation to seek assistance and provide that referral pathway. But it's one of a number of different similar type approaches. I'm thinking of the Vivian Bullwinkle Centre in the City of Melbourne, which provides a similar complementary service. There's the V Centre that is to be established later this year by VACI in Ivanhoe. They're all about providing a pathway for veterans to seek assistance where they need to.
And can I ask a question about the recognition of prior learning pilot program? Can you please tell the Commissioners about this pilot program and in particular the issues or barriers that the program is seeking to address and when it might move from a pilot program to a real program or when that assessment's got to be made?
Yep. So the recognition of prior learning program, the Premier touched on the gap that this seeks to address. It's very much about understanding that veterans have been extremely well trained, bring a set of expertise, not just in their training, but also in the way that they operate and how they can be terrific employees in either a government context or a private sector context or in as entrepreneurs, and making that translation between the skills and experience that they've derived through their service into a context that is understood and recognised by civilian employers. So we have created a program to pilot how best to make that translation. In some cases, it might just be, particular qualification in defence translates to X in a civilian context. In other cases, it might be that there are gaps. There's micro-credentialing required to make it in parity with the civilian qualification. So this is one way that you could achieve that outcome. The other way, in my mind, and perhaps I'm oversimplifying it, is that defence themselves could furnish people with qualifications that are well recognised in a civilian context immediately upon transition. In some cases, I think that happens, but I don't think it's universal. This pilot seeks to address that gap, and it's a 2-year pilot. During the pilot, we will assess and evaluate how effective it is, whether people going through the process are successful in achieving employment, and also how significant a gap this is for industry and for civilian employers.
Thank you very much for that. I just have 2 last questions. It's to take you back to the committee meetings and the task force meetings. I was just wondering whether the formulation of the veteran transition strategy was raised and discussed at either of those meetings?
It was. I attended a meeting in December 2021 of the task force on behalf of the minister who was unable to attend, and I remember and checked the minutes raising a point about, because the Commonwealth had done a presentation and said we're developing a veteran transition strategy, and I thought, this is great. Victoria, we'd love to be part of that. And I made that point, indicated that we'd very much like to develop it in partnership with the Joint Transition Authority. And then we learned of the strategy on Tuesday last week.
So you were given no opportunity to provide input or work together on it?
The Major General David McLaughlin, who the Premier mentioned earlier as the employment advocate, has attended every transition seminar that has been in Victoria over the last couple of years. It hasn't been raised with him, it hasn't been raised with me, it hasn't been raised with my director. I'm not aware of it having been raised elsewhere with the state.
Would you characterise that as patently unsatisfactory?
That's a fair assessment.
Commissioners, I have no further questions.
Thank you. Commissioner Brown.
Thank you very much. I might just go over a couple of the questions that the Premier deferred to you. The first one being the Victorian Veterans Card. Where are you at in terms of that implementation process?
Look, I'm really excited to announce that as of this morning, we've ticked over the 8,000 mark of people that have signed up for the card and now have it in their digital wallets. And in terms of the question that we ask about would those people be prepared to receive future communications from the Victorian Government, 99% of people have said yes.
And what number are you hoping to get to?
Well,
the 105,000?
I mean, in an ideal world, everybody would sign up for it. I don't know whether that will be the case, but certainly that is our aspiration.
But you did refer earlier to it being a parallel system to essentially what the Commonwealth is doing.
It's a way of, as the Premier indicated, thanking and recognising veterans for their service. Obviously, the discounts are modest, but they are designed to provide that recognition. And I guess for me, the foundational principle of the card is quite different from similar Commonwealth systems, like, for example, the white and the gold and the orange cards. They're very much about categorising veterans from the point of view of the extent of their injuries and their health conditions. This card, every veteran is eligible. There is no categorisation. It's purely and simply about recognition and thanks.
And I'm assuming, perhaps not correctly, but that if there were to be a national veterans card, that you wouldn't then need the Victorian veterans card.
I mean, I can't comment on future government policy, but that would seem to be a reasonable conclusion.
Okay. Do you know, the Premier told us that there are, I think, 1,100 veterans in the Victorian Public Service. Do you know roughly what percentage of the public service that would represent?
Oh, I'll need to take that on notice.
Okay,
I
no,
don't
that's
know
fine.
the quantum of the public service, but the number today is 1,287.
Okay, 1,287. And do you have, in terms of, you talked earlier about the committees, the various committees where veteran matters might be discussed. Is there a Victorian whole of government committee specifically around veterans, or is it just that the agenda items on veterans are put into the meetings of the other committees? I'm just trying to understand how you do it.
Yeah, it's more program-based. So, for example, if there is, and the Veterans Card is a great example, a program that is designed for veterans to deliver outcomes for veterans, then we, in this case, I chair a meeting with all of the other relevant government departments to ensure that we're in unison in our delivery model. So, similarly with the Mental Health Committee, the Disability Committee, the others are very much around issues. Could we develop one specifically around veteran? Yes, but then how would you determine the agenda items? There's different models, and the model that we take is program-based.
So, but can I just perhaps put the other side of the coin? How does the Victorian government address suicide prevention? Do you have a whole of government suicide prevention approach?
We do, and it's chaired by the Mental Health and Suicide Prevention branch of government.
So you have a suicide prevention committee where all of the various government departments come together to specifically look at suicide prevention?
Correct. And that committee is a subcommittee of the Secretary's Board, which is the heads of each of the government departments in Victoria.
Do you think there would be any advantage to having a whole of government veterans committee where you could then actually in one place oversight the various program initiatives that are coming through the other committees?
It's something that we could explore.
Okay, just interested. In terms of your consultation, you talked about the needing to understand what veterans need and how best to deliver it. So how do you actually consult and endeavour to understand that?
We need to do it in a range of ways. In some instances, it's veterans approaching Victorian government services for support, and then we find them that way. And I'm thinking of, the work in housing and homelessness, where through either outreach from our housing and homelessness services or through veterans themselves self-identifying, some 600 veterans on average have been housed each year over the last couple of years. Whether that is the entirety of people in need of such services, it's difficult for us to know, and that's why the ability to have that direct dialogue with veterans through something like the Veterans Card database is really helpful, because we can let people know that these services are available and that they are bespoke for veterans, and that they can be accommodated as part of it. So how we identify veterans in one way is through that process, in other ways is through hearing from ex-service organisations and referrals through that pathway, through the Veterans Council and the dialogue that they have with the sector, through the Minister's engagement, through our officer's engagement. There's a range of different inputs.
I asked the Premier in terms of the representation at CSTC, and you indicated it's the Director of the Office of Veterans.
Yes.
Just wondering in terms of then the feedback to the Secretary of the Department, and it kind of comes to, I guess, how not just the information flows, but the oomph, behind it, the drive to actually make things happen. Can you just tell us how that works?
So in the event that the Secretary or the Premier is engaged in any particular matter to do with veterans, then our office would be engaged to provide advice and briefing. And so whether it's the Minister, the Premier, the Secretary or me, or the Director, the information flow, I think, is effective. The oomph, it's difficult for me to comment on that, but I don't feel that there is an information gap.
Thank you. And just the last question, in terms of CSTC and having a greater mandate to plan and prioritise and progress, is it just, can it be done within the existing arrangements, or would there be a need to support that with something like a small office of the Secretariat, as happens with some other officials committees and ministerial committees?
I mean, I think the CSTC has a secretariat function through the Department of Veterans Affairs already. Obviously, that could be augmented and that could add some value, but to me it's more about having the accountability mechanism that requires a regular reporting on progress on particular initiatives that are identified, and whether that's a national veterans strategy or whether it's progress on outcomes in preventing suicide. All of that, I think, can be made in such a way as to be more robust.
Okay. I'll leave it there. I was going to ask you some health questions, but I took it from some of your earlier answers that perhaps that might not be fair to you. So
Thanks, Commissioner.
thank you.
Thank you. Commissioner Douglas.
Thanks, Mr Plummer, for your evidence. I only have one question related to the Veterans Card. I understand from evidence from other states that various states provide similar benefits but not the same. At this National Veterans Task Force, is there any discussion about any attempt to harmonise the provision of benefits amongst the states?
There has been discussion about harmonisation of concessions. It's been on the agenda at least for one meeting that I can recall. And I think there's value in that. It ought to be consistent, as much as we'd like to attract as many veterans as we can to Victoria by providing more attractive concessions. I think there's value in consistency.
I think some people don't appreciate the niceties of differences between Commonwealth and state levels of government and get some confusion sometimes when they move from one state to another. But
I'm sure that's the case.
thanks.
Thank you.
Just one issue which is somewhat in the weeds, Mr Plummer, and you may or may not be able to help me. We understand there was a group set up and funded by the Victorian government called the Victorian Veterans Family Services, which was perhaps funded through Legacy, and it was primarily to deal with and assist families in dealing with the Royal Commission. I understand it was defunded in April this year. Can you shed any light on that?
So it was an initiative that was originally funded, if I'm recalling correctly, 2 years ago, and the funding did conclude as part of the budget process that happened in May this year.
So was there any assessment done of whether the need still existed, the KPIs were being met, or any of that?
There was an assessment of the program delivery in terms of government decisions around funding. I'm not in a position to answer.
Appreciate if you can just take it on notice and let us know. It was brought to our attention as something that many families felt was helpful, and they no longer have it. So,
thank you.
Thank you. Mr Dighton, any questions from the Commonwealth?
No, thank you, Chair.
Mr Young?
No, please, the Commission.
Thank you. Mr Sheptoe, any matters arising?
Just one, Commissioner. I was just having a look at the Victorian Government website, and in particular about the Anzac Day proceeds, and I noticed that there were some funding from last year that was, I wouldn't say not insignificant, it's about $150,000 to a few organisations. You weren't able to say whether any formal evaluation process has been undertaken for those grants last year. Can I just ask that you take it on notice and come back to us about that?
Yeah.
Thanks. That's it. I have no further questions.
Thank you. May the witness be excused from his summons. Yep, so you're excused from your summons for appearing today, Mr. Plummer. Thank you for your evidence and thank you for the preparation you've put into it, the material, really comprehensive amount of material we've received from the Victorian Government. Much appreciated.
Thank you, Commissioner.
If there's no other matters, we'll adjourn briefly.
All rise. The Royal Commission into Defence and Veteran Suicide will adjourn. The Royal Commission into Defence and Veteran Suicide has now resumed. Please be seated.
Good morning, Mr. Rigotti.
Good morning, Commissioners. Commissioners, we will now hear matters concerning the termination of Defence members' service. Now, of course, termination of service can occur for a number of reasons. A member may choose to leave of their own accord. They may also be medically discharged. But other members may be involuntarily separated from the ADF. And it is that subject that we will address this morning. In particular, we will address the ADF's termination of members on the basis that the retention of their service is not in the interests of the Defence Force, and that is provided for under Section 24(1)(c) of the Defence Regulations 2016, the Commonwealth. Now, Commissioners, this topic warrants particular attention. The evidence before you has indicated that involuntary separation from the ADF is a risk factor for suicidality and suicide. In that regard, the Australian Institute of Health and Welfare has published data that reveals that between 2003 and 2020, the suicide rate for ex-serving males by reason of separation was second highest for those for whom the reason for separation was other involuntary separation. And that is the topic we'll address today. Added to that, Commissioners, this Commission has heard that Defence members often perceive early termination of service to be unjust, and we have received a number of submissions in that respect. Further documents received from Defence, in particular those pertaining to redress of grievances, indicate to this Commission that there are various issues, systemic issues that attend the early termination of a member's service. In that connection, Commissioners, you might recall the evidence of Dr. Jacqueline Drew that you heard on the last occasion in Adelaide, and that was on the 19th of July 2023. And Dr. Drew addressed notions of organisational justice and failures in organisational justice and how a member can perceive that they are treated by an organisation, particularly one such as Defence. And as Dr. Drew indicated, what they perceive as mistreatment can engender feelings of distrust, embitterness, and they're being resentful. And this can have real adverse impacts on their mental health and psychological well-being. Hence, this is an issue for some consideration. Now, within Defence's organisational structure, Defence's Career Management Agency has a role to play in the terminations of members pursuant to 24(1)(c) of the Defence Regulations. And in particular, Career Management Agency officers within each service have delegated authority to exercise the power of the CDF to terminate the services of a member pursuant to that regulation. You may recall, Commissioners, that during the Perth hearings you heard from SASR about the role of CMA within ARMY, And during the Adelaide hearings, the topic arose again in the context of evidence addressing careers, postings and promotions. Having provided you commissioners with that overview, you will now receive evidence from Colonel Jerry Page and Lieutenant Colonel Peter Francis, both of whom have the requisite delegated authority under section 24(1)(c, and you will hear from them about the role and responsibilities and activities of the career management agencies in relation to what is regarded as administrative discharges, involuntary separations. Might I ask the witnesses to be sworn in?
Do you, Geraldine Page, swear by Almighty God that the evidence you shall give will be the truth, the whole truth, and nothing but the truth?
I do.
Do you, Peter Francis, solemnly declare and affirm that the evidence you shall give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Thank you, Commissioners. There is a tender list associated with this session. Might that be displayed, please? And I tender the documents in the form indicated there.
Thank you. They'll be accepted into evidence on that basis and allocated the next lot of numbers. Thank you.
Thank you, Commissioners. By way of introduction, I will ask each of the witnesses to address their backgrounds and experience within defence. And Colonel Page, might I start with you? I understand that in 1996 you graduated from the Royal Military College Duntroon following service in the Army Reserves. Is that correct?
That's right.
Yes. And upon graduation, you were posted to the 1st Brigade and you completed command appointments at the 1st Command Support Unit and as a staff officer of personnel in Brigade Headquarters. Is that correct?
Yep.
Thank you. And you've undertaken numerous subsequent postings?
I have.
And among those postings in 2017, were you posted as Chief of Staff to the Career Management Agency Army?
Yes.
And in January 2019, did you assume command of the Australian Personnel Support Unit?
Yes, the Army Personnel Support Unit. Yep.
Thank you. And in that respect, were you responsible for providing personnel administration and transfer and transition support to Army units and members?
Was.
And is that around Australia?
Yes.
Thank you. And in 2021, Colonel Page, you were posted to the Director of the Officer of Career Management as Staff Officer Grade 1 postings. Is that correct? You have seen operational service, as we understand, in 2002 in Bougainville on Operation, is it
Belisi.
Belisi. And in 2018 in Afghanistan on Operation High Road, is that right?
That's right.
And Colonel Page, you're currently posted to as a Director of Career Management Support, Career Management Army, is that correct?
That's right.
And in that regard, do you lead a team responsible for managing lifestyle functions within the Army?
Yes.
And further, you are responsible also in connection of early terminations, is that correct?
That's right.
And we'll come to a little more detail about that. But prior to doing so, might I ask you when you commenced your current posting in the Director role?
I commenced in January this year.
January this year. And do you anticipate being in that role for, is there an indicated time frame or might you elaborate?
Yes, I have a 2-year posting.
2-year posting, thank you. Thank you very much. Lieutenant Colonel Peter Francis, you enlisted in the Army on the 21st of May 1996, is that correct?
That's correct.
And you completed your first 7 years as a soldier in the 2nd Battalion with the Royal Australian Regiment, is that correct?
2nd Battalion, yes.
Thank you. In 2003, you attended the Royal Military College Duntroon and you graduated in June 2004 into the Royal Australian Electrical and Mechanical Engineers, is that correct?
Correct.
And in May 2006, you were also deployed, in this case to East Timor on Operation Astute, is that right?
Correct.
And also Operation Slipper, is that correct?
Correct.
And then thereafter, you have been posted on a number of occasions, as the Commission understands, is that right?
That's correct.
And that included being posted on board HMAS Adelaide for 2 years.
It is also correct.
Yes, and might I ask when that was?
That was, what's this year? 2019, 2020.
Thank you. Lieutenant Colonel Francis, you're currently posted as well to the Career Management Agency of Army and you're Staff Officer Grade 1 there, is that right?
That's correct.
And you're responsible for separations?
So I'm responsible for the involuntary separations and also which is inclusive of MECRB, the prohibited substance testing, and also then the involuntary separations which we are referring to under 24.1 Charlie.
Thank you. And tell me, when did you commence this posting?
January this year.
As well, and again, do you anticipate being in that role for about 2 years?
I'm slightly different. I'm on posting at the end of this year, moving into a commanding officer role next year.
Thank you. Having gone through that biographical background, might I turn now to the subject of career management? We have heard a little bit about that in this Royal Commission, but we would be grateful if you would, just by way of background and contextualise the evidence we're about to receive, describe career management in the Defence. What does it entail? Colonel Page, I might direct that question to you, having regard to your position.
Thank you, Councillor. So career management entails the management of somebody's career from enlistment or appointment, including postings, promotions, course panelling, any other professional development, and supports them through promotion boards and posting considerations. And that also leads through to separation as well.
I see. And it manages the life cycle, the career life cycle of the Defence member, is that right?
That's right.
And how does career management fit within the structure of Defence?
So each service has a career management agency. So for us, it's Career Management Army. Only recently, all the career management agencies have moved into a new personnel division structure. Previous to that, Career Management Army was in Army headquarters, and with a one-star who has command over the different directorates within Career Management Army. The directorates are broken into 4 different areas that look after officers and soldiers based on what CERCAT they are, what service category, as well as my directorate, which provides the common enabling functions for those directorates.
And how many people are serve within your directorate? How many staff do you have?
There's approximately 90.
Yes, and responsible for the early terminations under Section 24(1)(c). Is that each of you, or are there others as well?
So that's within my directorate. So I've got 3 different areas in my directorate. That's one of the areas, and for which Lieutenant Colonel Francis leads that team.
I see. And might I turn now to the topic of delegations? We have mentioned that briefly. Would you explain the nature of the authority that is delegated to you and that you exercise in your current roles?
Sure, thank you. So our delegations are provided under CDF delegations. So depending on what rank we are, we have certain delegations applicable to the rank of the member. And they have been for involuntary separations centralised within CMA. So the only delegates for involuntary separation are in CMA, and they're in my directorate, of which is that part of the directorate that's led by Lieutenant Colonel P. Francis. Again, the delegations that I hold are up to a certain rank to make decisions about members, and they are delegated down to SO2, Staff Officer Grade 2, which is the rank of Major, to make decisions about members of a lower rank.
I see. And it's correct to say, isn't it, that the Chief of Defence Force may delegate, or it delegates that authority pursuant to the Defence Act 1903 and concomitantly the Defence Regulations to which I just referred.
Yep.
And the Act and the regulations outline the authority for the administrative involuntary separations that we are addressing.
Yes, yep.
Now, before addressing those topics in detail, might I ask you, each of you, to explain your requisite roles and reporting lines within CMA, and how often each of you have considered involuntary separations under 24(1)(c). So in the first instance, roles and reporting lines, please.
Thank you. So my role as the Director of Career Management Support is my director is responsible for delivering those common enabling functions for the other directorates. They're broken into 3 main areas. The first one is selections and appointments, which deals largely with Army Officer Selection Boards and service suitability checks for re-engagement. The second area is training and transfers, which deals largely with course panelling and all the different transfers that may affect someone in their career, from trade transfer through to service transfer, CERCAT transfer or voluntary separation. And the third area is the involuntary separations and MECRB, which is led by Pete. In that team, that's broken into involuntary separations and MECRB. Looking at the involuntary separations, a piece that you asked, I have not made any decisions around involuntary separation of a member that I have the delegated rank for this year.
Thank you. Lieutenant Colonel Francis, might I invite you to respond to those questions?
Certainly. So my roles and responsibilities. So I'm SO1 separations or transitions is my title. As part of that, that requires me to command and manage the team across 3 different areas. So firstly, the MECRB, which has been mentioned previously, that sees me provide command and management over sort of 3 delegates. One of those delegates is myself, where we look at approximately 300 cases per year from the MECRB side. We have then a team underneath that of APS and also military members who do mostly the administrative functions. So the key thing there is the 3 delegates. The next part there is the invol separations portion of it, which looks after the admin under 6 bar 24, sorry, 6 bar 2, not in the interest. That is a team of 2 delegates, 2 major level delegates that looks after approximately 300 cases per year for all of the not in the interests. And then finally, the last part is the prohibited substances testing coordinator, who's a one-off, who looks after all of the prohibited substance testing actions, and which would obviously result in possible separations from defence. Key to note, I think, is there that not every determination, not every case, as you would see by the numbers, results in a separation. We sit at about 30% retention under 24-1 Charlie, and we get a higher retention rate in terms of probably about 60% for MECRB. The other key function that I just wish to note as well is that we provide the delegate function and the decision function for Army under 24-1 Charlie, which is what we're concentrating on today. We do not provide a face-to-face command-oriented function from the member. So we are purely a centralised decision delegate function.
Thank you. And you report to Colonel Page?
Sorry, yeah. So in terms of reporting, Colonel Page is my first level supervisor, and then the DG CMA is a second level. Yes. In terms of the time frame that I've been doing this for, in terms of delegates, it is since I posted in from January.
Yes, and have you had an opportunity to consider any early terminations under 24?
Certainly. So I have done a number. It's not as often that I do 24-1 Charlie. Majority of our separations are at the rank level that can be that is within the delegation of the 2 majors that do that work. I get involved when it is a rank-related delegation, or alternatively, if we have to review a situation that requires more of an independent delegate to look at that. Predominantly, most of my work is 24-1 Alpha through the MECRB.
I see. But just staying there with 24-1C, I understand that you don't get involved in the majority of those considerations because owing to the rank of the particular member, and there's someone below you who can address that issue. You did mention there might be certain circumstances in which you would become involved. Notwithstanding that, could you elaborate on that a little bit for me?
Certainly. So as the SO1, my role is to command and manage the team and lead the team. So in terms of an understanding of making sure consistency across decision making. We do internal training ourselves, which is required from me to organise that for the team to make sure we achieve that level of consistency. If it's a complex case, my SO2s will often come and seek advice in terms of a sounding board, I suppose, to ensure that we're once again maintaining consistency and a level of having the correct decision made at the end, because once again, individuals, based off the knowledge of the case in front of them and all the information in front of them, may have a couple of areas that they wish to then sound off another more senior person that may have had more experience in Army, more experience in command, or the like.
I see. Thank you. Now, having addressed those matters, might we display, please, operator, the regulation that we presently have under consideration? That is Regulation 24.1 of the Defence Regulations 2016. And when that comes up, you'll see, Commissioners, the various matters that we are addressing, and that the Chief of Defence Force can, of course, terminate a service of a member for a number of reasons. They're identified in the regulation. So we have the defence regulations there, and if we can go, please, 24.1, early termination of service. I'm grateful, operator, and if you could focus there. Yes, please, thank you. So you'll see there the precise wording, Commissioners, of the relevant provision, and in particular, the members may be, the Chief of Defence Force may terminate the service of a member for the reason we have in mind here. The retention of the member's service is not in the interests of the Defence Force. And you'll observe there that we have to go to operator subregulation 6.2 for the definition of interests of the Defence Force. And whilst that is being brought up, as you understand, what is meant by the term "not in the interests of the Defence Force" covers a number of reasons, and you'll see down there, operator, at number 2, subsection 2, and those reasons are enumerated there. So you'll see, Commissioners, there are a number of issues that come to bear, issues relating to performance, issues pertaining to behaviour, suitability to serve, whether it be in the Defence Force as a whole or in a particular role or at a particular rank, workforce planning, and then separately the effectiveness and the efficiency of the Defence Force, and then finally the morale, welfare and discipline, and then the reputation and community standing of the Defence Force. Now, it's correct that the definitions there aren't exhaustive. Is that accurate to say?
They're not exhaustive, and yeah, the things that we would consider fall within those. So performance would be on a spectrum as behaviour, etc.
I see. Now, so it is your practice, notwithstanding the language of the regulations that provides that it may include one or other of those reasons. And that rather suggests that others that aren't listed there might be considered. Is it correct to say it's your practice when considering an early termination to have regard to one or other, or perhaps a number of the reasons identified there?
So I think in answer to that question, most of the subsections are from this section. So we would not separate someone necessarily outside of these.
I see.
The subsections of what you're alluding to in terms of the non-exhaustive list of specific actions come out in other things such as policy, CA directives, CDF directives, in terms of an understanding to highlight areas of this of 6/2.
I understand. Now, when we have indicated there categories such as a member's performance, you can see that the categories are fairly expansive. Could I ask each of you perhaps to provide some examples in order to inform the Commission of the type of conduct or alleged conduct that might fall within each of these categories?
Sure, thank you. If I can just qualify my previous answer as well that I made around involuntary separations, there were separation decisions around 24(1 Charlie. That didn't include MECRB decisions or anything under the Defence Act for notice of positive test result. If I can look at performance here as an example, that could include repeated or an instance of failing a fitness test or repeatedly despite sort of being given opportunities for training. Behaviour can include anything from unacceptable behaviour, bullying, sexual assault, sexual harassment, and those sort of behaviours. Suitability to serve is often assessed under what we call a PS006, which is a psychologist assessment that's command referred by command, and they may be requesting a psychologist recommendation on their suitability to continue service. That's a couple of examples from me.
Yes. And Lieutenant Colonel Francis, I might ask you to continue the list. We have there the failure to meet conditions, but also, which would, if you could elaborate on that,
so,
and then workforce planning and the like.
Yep, so as part of the an appointment or a member coming into service, they will sign basically an agreement to say that they will achieve the following conditions. If one of those are not, well then it is that we have the ability then to look at that as a possibility for separation from defence. Workforce planning is not a well-used one necessarily in terms of the only example I can provide you for that is if Army or shuts down an ECN, so a category or a trade, and you are then no longer qualified or don't meet the requisites to go to be core transferred perhaps, it may well be a workforce planning.
Would that be in the nature of a redundancy? Might it be something like that?
Certainly, yep.
Yes.
Effective and efficiency of defence. So the last three really talk about the organisation and the organisation's requirement then to ensure that we fulfil our obligations to government, i.e. defence is required to maintain a level of capability, a level of deployability in order to go and fight the requirements that government sends us to fight. Morale, welfare and discipline is also then coupled to that in terms of depending on the member's situation, that will have an effect on the team around him or her and may have a negative effect on that organisation. So that could be taken into consideration for a separation. And the reputation and community standing. So the community expect a certain level from the Defence Force. If we fail to meet that, much like any other forward-facing or public-facing organisation, if we fail to meet that in our behaviours and standards, well then that has significant risk to the reputation of Defence.
I see, thank you. And when it refers there to the early termination, not here but under Section 24(1) of the relevant Act, the regulation. Of course, it's not so much early termination; it's simply termination, isn't it? And that can occur at any point in a defence member's service. Is that right?
Yes. In terms of the early termination portion, like you will sign your ROSO, so you'll sign on for a certain period of time, so 4 years perhaps. So that just without being a legal person, that would then just indicate that we were able to separate prior to that.
I see, so that's your understanding of the context in which that language is used. Thank you. Coming now to the termination process, I'd be grateful if you would explain to the commissioners, step through the process by which a member might be terminated, or there might be administrative action to initiate the termination of a member's service. Colonel Page.
Sure, thank you. Commissioners, an event may occur, an action or a behaviour, and the command team, the CIO, may make a decision to issue the member with a cessation of notice, a cessation of service notice, what we call an ICSN, and they will issue that to the member. The member then has the opportunity to respond to that and provide a statement of reasons. The member can also, in the putting together the statement of reasons, seek the support of others to include information in that pack. And that can also include performance reports, references and that kind of thing. The CO then makes a recommendation upon receipt of the member's statement of reasons, and then that pack is forwarded to the delegate within CMA. So what the CMA delegate has to look at is the initial ICSN, which talks about the action, the member's response, and then the CO's recommendation based on that member's response. And then that's sent to us for a decision.
Thank you. And Colonel Page, I might ask you just to elaborate on some of the definitions. And I've seen there's an MPT, which is a notice of proposed termination. You've referred there to an ICSN, and I think there might be another acronym, not unsurprisingly, that pertains to these various notices. Could you explain what each of them is, whether they're the same or they're different, and how they work?
Sure, thank you. I think Air Force used the term NPT, which is Notice of Proposed Termination. Army uses the term Initiation of Cessation of Service Notice. It's the same thing.
Thank you.
And I don't recall what the other one was.
Let me see if I can assist you in that regard. The other one is the notice to show cause. Does that occur at a different point in time, or is that the same notice again?
It's the same thing. I guess what the ICSN is, it's a notice for the member to show cause why an action wouldn't occur.
Can I possibly add some context surrounding that?
Yes.
In terms of the ICSN is the ICSN is the finalisation of a possible separation. There are many more actions that occur prior to that in terms of a notice to show cause as to or available to the CO. Not all actions will result in an ICSN.
I understand.
So they may well result in DFTA. They may well result in a notice to show cause as a formal warning. By the time it comes to ICSN, that is a purposeful action by a CO or a command team to then initiate a cessation of service notice.
And the exercise of the delegation that has been given to each of you.
Yeah, so a CO may make a decision not to proceed to that length. They may just issue a notice to show cause for a formal warning or something.
And we do, have certain areas where there's a mandatory raising of an ICSN, where the power is taken away from a CO to say, if this occurs, an ICSN must be raised. You have no right to then go at a lower form of sanction.
Yes, thank you. And you mentioned there, Colonel Page, a package of material that Command provides to CMA. Was that, I understood that correctly?
Yes.
And in that package of material, I believe you mentioned a member's response. Is that correct?
Yes.
Might I ask operator for you to display, please, Section 30, Regulation 30 of the Defence Regulations 2016. That's on page 17 of the compilation you have. Whilst that's being brought up, just by way of background, that 30 refers to the notice to members. Now, this, as I understand it, is the regulatory context in which we have just been discussing the notices, and what is set out there is the nature of the information that needs to be contained in that notice. Is that right?
Yes.
And So there it needs to state the action that is being proposed. In this case, it's the early termination pursuant to section 24(1)(c). Is that correct? Yes. The reasons for that action, and then you'll see there's the invitation to the member to provide a written response as to why the action should not be taken, and the facts and circumstances necessary for the member to prepare the written response. By that is the reasons that Command has for wishing to terminate the member's service. Is that correct? And you'll see there also it specified that the notice must specify the period for providing the written response. What is that period?
14 days.
Thank you. And then
it can be extended if required.
Yes, and the question of extension I'll come to in a moment. If we drop down there to 30 subsection 2, it says that the action must not take place before one of the following occurs. In particular, the member provides a written response or indicates in writing that they do not wish to respond, or the period for providing the written response ends, and that period is the 14 days ordinarily, to which I think you've just referred. Is that correct? So really, this section here is the necessary requirement in order for CMA to consider the material that comes from Command to it in respect of the early termination. Is that right? So unless one or other of these things have occurred, you're unable to consider that material. Is that correct? Thank you. Now, you've indicated that that period of time, namely the 14 days, can be extended. Might you explain to the Commission the circumstances in which that might occur and how consideration is given to any extension request or otherwise?
Yeah, so this one here is at the CO level or the unit command or the command level. So the commander has initiated, so there's an initiating authority and an imposing authority. The commander is the initiating authority. They will write up the period of requirement for them to have their statement of reasons in. If that time period requires extension, that is at the requirement for the CO to then extend it. The certain factors that will impact that will be perhaps the member has not been able to access a legal officer. Perhaps the member has not been able to access, a relevant support officer that can give him or her advice. So any of those examples will render a member to then say to the CO, the initiating authority, to say, I don't feel like I have had the time to answer and provide my voice correctly to answer this document, so therefore I request an extension. So as long as it's reasonable, then the CO should extend.
I see. So then to unpack that and understand that, the responsibility or the decision maker in respect of the extension of time, is that the CO or is that ultimately the CMA?
No, so that part there in terms of decision and initiating authority and imposing authority, two separate things.
Yes.
So at this stage, CMA have not received the ICSIN.
No,
So at this stage, we are not even looking at the member. We're not looking at the context or anything around it. We are awaiting the finalisation, as per the regulations, for the CO to then send it to us once these have been met.
I see. So I take from that then it's the CO's responsibility to determine whether or not an extension is granted to a member to respond. I see. And when the material comes to you, the package that comes from the commanding officer, you've mentioned there that the initiating authority is the commanding officer, and you've mentioned also an imposing authority. Are you then, the CMA is then the imposing authority? Correct. Is that right?
Yeah, so if you link imposing with a delegate or a decision maker.
I see. Separately from that, when it comes to the request for an extension, does the CO wear two hats, as it were, both the initiating authority in identifying that there ought to be a consideration of early termination under section 24(1)(c), and also an imposing authority when it comes to consideration of any extension request?
So I would de-link those two terms. The CO will always remain the initiating authority.
I see.
However, it's on the CO to then ensure that the member has either provided the response within 14 days or the member states in writing on the acknowledgement form, which will then get sent to us, that I choose not to provide a statement of reasons within the 14 days, or the period for the response has ended. So the 14 days has ended. The member is still either has or hasn't provided a statement of response, and then it will get sent to us, or has not provided a request for an extension.
I understand. And the acknowledgement to which you've just referred, how is that obtained? Say when we talk there, the 32(2)(b), if I could just ask that to be brought up again, Operator, I'd be grateful. Where there's a reference there to the action must not take place before, say for example, that the member states in writing that he or she does not intend to provide the written response. Is that an acknowledgement obtained by the CO, or is it obtained by some separate or in some separate manner?
So obtained by the CO. So once again, ICTION is briefed to the member. It's basically saying this is my intent to tell the decision maker that I intend on recommending that you be separated from defence. From there, member has their right of reply, always. After the right of reply, CO then has a read through the right of reply and goes, you know what, that has merit. Then legally as well, the CO then does not need to send it to CMA.
I see.
If they still think that it has no merit, confusing myself, they will then send it to CMA. But they must tick off the last, those three actions. So it's either the member saying, I am not going to provide a statement of reasons, or the member provides a written response within the 14 days and then it can be sent to the imposing authority.
I understand. And
The imposing authority decision maker, will not even know about this or start making a decision until the information pack is sent.
that's right, and that is sent after one of the following occurs.
Correct.
Thank you. And for the transcript, the following was my reference to 30, subsection 2. Now, you've mentioned there that the member has a right of reply. I take it that pertains certainly to the substantive factual allegations upon which the CO relies for the purposes of termination. Is that correct?
Yes, it'll talk about the facts.
And then separately, I want to ask about any request for an extension. If a CO declines an extension request, does the member also have a right of reply in respect of that?
I would suggest, and in my time I have not seen that, but I would suggest absolutely. It's written in regulations that they can seek an extension. So it would be very rare that a CO would say no to that in my experience.
Thank you. And tell me, are you aware of any policy that provides, that assists command in that respect to understand the procedural steps, because they may not necessarily be always across the matter of the regulations, but to understand the procedural steps when it comes to members being able to respond to a denial of an extension request?
Not about a denial of an extension request, yeah.
And when the package comes to you, and I'm still interested in this question of a request for an extension. If a request for an extension is denied, do you as the delegated authority in CMA, is it within your delegation to consider not only the substantive allegation, but also the refusal to extend the time?
So I guess the answer to that is as long as it's written down, recorded, and provided as part of the pack.
I see. So,
and if I can add, if we received a pack and the member had stated in writing that they intended to make a response, and then the pack came in without a response,
yes,
we would more than likely go back to the unit and ask what's happened.
could be an administrative error, as in the response has not been sent as part of the package, perhaps.
I see. But if you have regard to the relevant section, there are the three options. Either the member provides a response or he or she doesn't. But I should say states in writing that he or she does not intend to provide a response. But then the third section there, that the period for providing the written response ends, that could encompass circumstances then where you get a PAC, it's a command referral, and the PAC's just silent as to whether there is any intention by the member to respond, because the time has simply elapsed and it's then thereafter sent off to you. Do you make any inquiry of the commanding officer about this matter, whether the member had indicated they wish to respond or no?
So in terms of that is a question, for me, is a hypothetical, because I have not seen it an exact, I haven't experienced that. So in answer to the hypothetical, I tell my team that where there's anomalies, they must, and it is a requirement to then go back to the CO or the unit and figure out the anomalies. So it may well have just been a perfect, as I said, the statement of reasons might not have been put into the package that was sent to CMA. It could well be that the member said he or she was going to provide a written response. The time elapsed and they just didn't bother and informed the CO that they weren't going to bother.
I see. So is it your experience that generally the PAC is not silent as to whether or not there's a written response? There's either one, there's an indication there won't be one, or there is an indication that the member wants to make one.
So I think
it will be attached.
Yeah. So I think in the way we write our templates and the way we structure our templates, in order to then for COs and members to follow the process, my assessment is that anomaly would be picked up.
I see. So going through the process, stepping through that, you've received the PAC from the commanding officer. What is the nature of? I went through by reference to the regulations, but I'd be grateful if you could just elaborate on the nature of the information that you ordinarily see in this package of material received from the commanding officers.
So the ICSIN pack, as we refer to it, will have everything as previously mentioned. So it will have the full package and annexes and evidence pack that the CO has provided to the member to say, if it's a performance-related thing or a behaviour-related thing, as part of the ICSIN, they will have annexes as to, for example, they'll have their reporting history. As an annex, they will have perhaps some evidence that they were charged for certain behavioural issues on this date. That we will also then, so that's the ICSIN package, which we encourage our commanding officers to put as much information into that as possible. They will also then have the statement of reasons from the member, which is the member's right of reply, and maybe not, it is a right of reply, but it's also their voice to the decision maker as well, because we read all of it. And then any other evidence that is provided as part of that ICSIN pack.
What might that other evidence be?
I'm trying to think of an example.
It might also include in the member statement of reasons, it may include referee reports, it may include a Padres report, it might include their PARs, which support their performance and things like that.
Sorry, so going back to your previous question as well, it includes, the package includes as a templated version of the member's acknowledgement, which the member will then sign off on the number 2 there, in some boxes, whether they say, I'm going to provide a response or I'm not going to provide a response and I'll waive it. So there's that acknowledgement as well in terms of.
Yeah, So it's a formalised template. So when the notice goes out, it includes the acknowledgement form for the member to tick yes or no. So that it comes back with that. So we know the member's intention.
Does that answer your question?
It does, thank you. Now, so that is the information that you receive, that's the information under consideration. Do you, as CMA, as a delegate, do you go out and then speak to the member or speak to command or to the padre or anyone else who has provided relevant information?
No, so as I said previously, our role within CMA is purely a delegate decision role. It's not a face-to-face. The face-to-face discussions with the member will be done at the CO level.
I see. So in order to understand that, then the information that you consider is only that you receive from the commanding officer?
No. So I'll elaborate now. Yes. So once we receive a Nixon pack,
yes,
I have a very small administrative team,
yes,
that will then go through all of the admin to bring it into the system, create the package for the delegate in one central location where they can see it, review it, all the information. As part of that review process, my team, the admin team, will then look at certs, and I'm going to apologise because I actually cannot remember.
Conduct tracking in our HR system.
Yes.
Yep. So they'll look at certs, they'll look at their behavioural history on the dossiers. They will input into our database things like, which are very relevant, things like age, things like time in rank, things like posting history, anything else of relevance, which then all goes to the database. All of those things are then utilised as part of the decision-making process.
Essentially what we receive is a written representation of the process from the CO and the member and all the supporting evidence. So it's almost as like everyone was sitting in a room, it gets put onto paper, into a report, and so we have all of those things in front of us, or the delegate does, to make a decision.
I see, thank you. And to the extent you do seek additional information of a limited nature, it would seem, at least of prior behaviour, recorded prior behaviour, does CMA then go back to the member and seek any, if that forms part of the decision-making process, and there might be some history of conduct, do you go back to the member and ask for an explanation of a further explanation in light of that additional material?
Depending on the information, and sorry, it's remiss of me not to say that part of the checks look at their MEC status. In my role, as previously discussed, I look after MEC-RB and I also look after InvolSeps. One of the checks and balances that we do is, has this member been initiated into the MEC system? So we will look at that because that then has another impact on the decision-making process.
And why do you consider that has an impact on the decision-making process?
So as part of the, which is, we're updating our templates now, so to go back slightly, in the prohibited substance testing template for COs, we have actually, and also the CA's directive, we actually specify to say the CO must look at causal factors, possible causal factors that led to perhaps some of the parts as to why the accident has been raised. We're not saying these are an excuse for poor behaviour. What we're saying is there may be some causal factors, be it MEC, be it psych, be it problems at home, be it a gambling addiction, be it anything else like that, that may lead to the kind of behaviours that we're looking at possible separation for. And I apologise, I forgot the first part of the question.
That's right, I'll return to but I'm grateful for that information. So let me return to the question. Is when you look at some additional information, once you've received the pack and it's been processed and you go back to look at behavioural matters of behavioural history, do you then provide that information to the member to indicate to the member that that information is going to form part of the consideration as well?
So
seek their response.
Great question based off the admin law that we look at. So hence we have a legal officer that will look at that on a case-by-case basis, and then if we identify that this is then going to formulate some sort of a procedural fairness issue, i.e. we're bringing in new evidence, or what can be perceived as new evidence, we will then go back to the member. This is our current process. Go back to the member through the CO with an additional procedural fairness minute to say, as part of the process, we've identified X, Y, and Z. It was not mentioned in your ICSIN. However, or alternatively, we can then work through the CO and say this was also been brought up, and it needs to be passed through the member for procedural fairness. So we do look at that. However, on the templated version for the ICSIN, we do also state all of the areas. So all of the areas we currently input and then look at as part of the building the pack are part of the ICSIN to state that we will look at these areas.
I see. And
Or they will formulate part of the decision maker's decision.
I understand. Thank you. And when you go back to the member, you go back to the member either through the commanding officer or also the member directly, or no, always through the commanding officer?
No, so yeah, we try not to step over our role as decision makers. The role of the CO is to look after the member, including their welfare support, their support officers, and all sorts of stuff through the process, and they're directly responsible for the member. So therefore, we try not to overstep our mark. We will always go back through the CO.
I see. And I'll come to the role of the CO in a moment, perhaps after the luncheon adjournment. But just before we get to the luncheon adjournment, I just want to understand a little bit more about the pack that you receive. Obviously, it all comes from the CO. Of course, you don't know, do you, what the member has or has not seen for prior to providing his or her response. Is that correct?
So they'll receive, so the whole process will be initiated with an ICSIN, and in it will, and we've got templates for it, I'm not sure whether they were submitted, and it will be addressed to the member, and it will say something along the lines of this action has occurred, and as a result, we are going to initiate this action. These are the facts given to the member. They acknowledge it, that it's been received. They acknowledge whether they're going to make a response or not. And then with that, they take that away. It's theirs. They take that away and formulate their response through support of a legal officer, another support officer, and then they put together their response. The CO then has the initial notice, the ICSIN, has the member's response. On top of that, the CO makes their recommendation based on the member's statement. If the CO decides that it needs to go to CMA, taking into account the member's circumstances and what they've said in their statement of reasons, the CO will make a recommendation as to whether early separation is appropriate, or actually that the CO considers that there are mitigating circumstances. Then that all gets sent to CMA. So it's essentially notice, which the member has, statement of reasons from the member, CO's recommendation, and then that comes to the delegate.
So key missing point there was the member acknowledging the member acknowledging the CO's recommendation. So at every stage,
Yes, yep.
Backwards, forwards. So therefore, CMA should not receive anything, inclusive of the CO's recommendations, without the member's acknowledgement.
Yeah.
Is there ever a risk that the CO might, for whatever reason, include within the pack material that the member has not seen? And if that exists, how do you seek to mitigate that risk?
So in terms of the process and procedure we follow, I feel it's robust enough to mitigate that. So if there's no member's acknowledgement on the CO's recommendations, that's a flag for us as well, that perhaps the CO's recommendations haven't been acknowledged by the member. If the CO makes in his recommendations, brings up new material that has not been in the ICSIN, we will send that back to the CO because it lacks procedural fairness to ensure that the member has been sufficiently briefed on the new information.
Yeah. Is there any document or template whereby each item of information or each document to be provided to CMA it has to be initialed or signed off by the member to ensure that there's no risk of additional information going through, even inadvertently. I'm not wanting to characterise it in any way.
Yeah, so we would only see the ICSIN, which the member has, the member's response, the CEO's recommendation as a result of the member's response, and the members signing that they have seen the CEO's recommendation. I don't think we've seen a pack that has anything in addition to that.
So I take it then that that's a no. Do you think that would be a valuable additional document from CMA's point of view, just to ensure proper process, if I can put it that way?
So
Is there something there already?
the only other way I can see that would meet your requirement would be for the member to sign each individual page of every document.
Which we could.
But I don't know what the member's signature looks like regardless, so it could be forged.
I see. Thank you. Commissioners, I note the time.
Yes, certainly. Before we go, though, I'm sorry, I just need to clarify this issue. So there is no list of documents that are tendered in the pack that the member sees before it comes to you. A list that includes everything that you're receiving.
So no, so the member, sorry, Commissioner, so the member receives the full pack. So, but
Yeah.
in answering your question, no, there is not a final document that says I have reviewed the ICSIN, my statement of reasons, the CEO's recommendations, and then there's no document currently in our templates that would get this member to sign that to say that they have viewed all of those documents.
This list of things.
Yes.
How can you then be comfortable that the member has seen everything that has been tendered to you?
We only.
I'm sorry, Colonel, before you actually answer me, we've certainly heard enough evidence to suggest that when people fall out with their chain of command, that's the sort of thing that happens, that things are said about them that they don't get a chance to know about, let alone respond to. Forgive me for being blunt.
No, and that's distressing to hear. I'd like to think that we act on the ICSIN, which the member has seen, and that's the member's statement and the CEO's recommendation, and that's what we receive. But I take the point about the checklist, and it's a very good idea.
Yes, I think we acknowledge that as a possible shortfall, and we'll take that on board. Absolutely, we're here to learn as much as provide evidence too. So, thank you.
Thank you. We'll adjourn and then we'll learn some more after lunch.
Thank you. Thank you.
All rise. The Royal Commission into Defence and Veterans Suicide will adjourn until 1:30. The Royal Commission into Defence and Veterans Suicide is now resumed. Please be seated.
Thank you, Ms. Ribagotti.
Thank you, Commissioners. Yes, thank you. Thank you. Operator, might I ask you to display the following document? It's DEF.1220001.0059. This is the Members' Guide on Adverse Administration, the Involuntary Separations document of February 2022. Are you each familiar with that?
Yes.
Thank you. And just to understand the nature of this document, it provides a member with information in relation to the process under section 24(1)(c). Is that correct?
That's correct.
Thank you. Might I go, please, operator, to the next page, 0060, and if you just focus on the words there, bring all of that up just a little bit larger, both for me and the witnesses, I'd be grateful. We'll see there, we've heard about the information that you take into account that is received from the commanding officer, and we've heard also that regard will be had in CMA to the record of the member's prior conduct. I note in this document, if you can just, you'll see here an introduction to what the guide is, as we were just discussing, to assist the member in understanding the process that will apply to them in respect of early terminations. Under the note there, I just note the first sentence, and I will come back to that, but being issued with a notice to show cause or involuntary cessation of service notice is a stressful event, and it's not uncommon to feel overwhelmed. And we'll come back to some of the issues that attend members having regard to the nature of the process. But prior to doing that, we note in this document that it states in the following sentence that you're, unlike disciplinary or civil punishment processes where your good character and references are taken into account, and it says there, to a far greater extent than when subject to adverse administrative action, meaning that the incident, your behaviour, your actions was more likely to have occurred than not. Just to understand what is meant there, is it the case that when it comes to the consideration of a termination under 24(1)(c), issues of good character and references are not considered unless they form part of the pack, or are not considered at all? Could you explain that issue, just as it's identified here, just to assist the understanding?
So there absolutely can be considered in terms of if you wish to put that in part of your statement of reasons, to talk to character behaviour, depending on what the level of the ICSIN is. You can put it in your statement of reasons.
I understand. Well, might you assist the Commission in understanding what is said here about, it would appear that good characters and references are not considered to the same extent that they might be in disciplinary or civil punishment processes? I don't know if you can assist.
I think what that refers to there is, I guess it's the same, the different standard of proof that's required for disciplinary is also there applied to good character. So the same for administrative action, it's the balance of probabilities rather than beyond a reasonable doubt. So a lower, I guess, evidence of the action behaviour can warrant administrative action, and potentially good character and references do not need to be as articulated as what you would take to a disciplinary hearing. Good character and references are absolutely taken into account in someone's statement of reasons, including when members have references written for them as well.
So I would add that this is not a policy document. It is not stringent. It's supposed to be a guidance for the members. 100% it's an evolutionary document that if we're creating confusion here, I'm absolutely happy to amend this if that's what the outcome is.
Might it be, referring to the confusion there, might it be the case that it may be a deterrent to members to provide references or information going to their good character, having read this, because it might convey the impression it's not taken into account?
Yeah, so certainly if that's the perception that an outsider would read into it, well then that's probably the perception that a member will read into it.
Yes.
More than happy to amend this so that it clarifies it, absolutely.
Yes. And as to when they might be taken into account, I understand from what you've said, it certainly can form part of the pack that comes from command. If after your process of processing, if I can put it that way, that pack, and you identify the record of prior behaviour, can further information be sought from the member in respect of the issues that are identified in the matters of prior behaviour?
So
and
I think,
some explanation.
Yes, I think that's why in the ICSIN format we specify what the ICSIN is concentrating on for a possibility of a separation. In terms of that then provides the member the agency to answer the question in their statement of reasons, or argue the question, or argue the ICSIN appropriately, rather than wasting time on areas or information that weren't utilised as part of the ICSIN.
Yeah, thank you. Now, might I turn to the question of how about you go about weighing the evidence up? Again, just referring to this document a little further down, operator, if you could turn to the next paragraph. Administrative delegates want to understand what led you to the actions that the relevant notice is about. Does that suggest that there is a presumption in favour of the matters that are stated in the notice? Is question number one. It presumes that those matters have been established, and that the member needs to merely explain the reasons for them, or is there a question of ascertaining whether in fact the facts are, as alleged, occurred?
So as per my previous comment, so the purpose of this line, as I read it, is to tell the member, don't give me your whole career history, specify or concentrate on the areas that were specified as to why an involuntary cessation of service notice has been initiated.
Yeah. And that can include, obviously enough, just disputing the allegations made, as well as providing an explanation for particular conduct.
So for an example, if this specific ICSIN was raised because of a organisationally unfit, based off a PS 006, which is a psychological document, then perhaps arguing that my behaviour has been good to go throughout my career is possibly not necessarily a waste of time, but it's not answering the question or arguing the fact that you are organisationally unfit for defence.
And how turning then to the weighing of matters, and when it comes to the exercise of your delegated authority, how do you engage in that process of weighing up the information that is before you? Is there the policy that guides you? Maybe you could refer to that.
Certainly.
And then talk a little bit about that process.
So I can commence if you, sorry, ma'am. I can commence if you wish. In terms of, there's obviously policy and guidance for all decision makers. Mill Purseman, specific chapters, the GADDAM is another document to formulate how we create decisions. We've also then got specific Army policies in the ASIPs. We've got which specify how and what you should look at as part of your decision-making process. And it's not just about the process; it's about the member that you're talking about as well, in terms of their age, their seniority. Someone that is perhaps younger in age and very junior in their career will be held to a probably. Lower standard is probably a poor terminology, but as opposed to a warrant officer that has spent 20 years in the Army and ultimately should know better.
That's it. And factors external to the members' conduct, to what extent do you take into account service capacity, pressures on workforce and the like? Colonel, perhaps you can address that.
Yeah, so if that's addressed by the member of their statement of reasons, they can put that in there. Also, any personal circumstances, so any changes that's compelling or compassionate in their family, any changes in their work environment, they can put in any sort of considerations around unacceptable behaviour towards them, bullying, or any concerns they've got as well. They can raise that in their statement of reasons as well.
Thank you. And separately from that, issues around retention. Now, I understand, Colonel, as part of your previous position when you were posted to the Directorate of Office of Career Management, one of your responsibilities and that of your team was to look at workforce hollowness and competing priorities. With that background, are they issues that are relevant to the to determinations under Section 24(1)(c), and if so, how?
I think we would be looking at, in terms of workforce hollowness, we could be looking at what type of role the member was doing. Were they doing more than one role? Was there what sort of pressure was on them at the time? And if you're asking about retention, would that be a consideration to retain someone? I think the risk appetite can change around, some behaviours, and we may decide to keep someone and give them another opportunity. We can put a lesser sanction on them to then make sure that there's a protection for the organisation. I can't talk to any specific cases, but retention could be a consideration, particularly the members of a particular trade or something like that.
I see, thank you. And when it comes to returning to the member and your consideration of any extenuating circumstances, you mentioned, I believe, their MEC status. Do you make any inquiry, any additional inquiry? I think the answer is no, but do tell the Commission as to whether there are any extenuating factors beyond what is identified in the command package or in the review of the records that you've referred to? By which let me try and rephrase that. So there may be a circumstance where a member's behaviour that is the subject of the notice is perhaps caused by another matter, and you've identified that MEC status as perhaps something to be considered. But if it's not recorded there, how do you go about ascertaining whether there's some underlying issue? Do you do that, or is the answer no?
So once again, I'll go back to one of my previous comments, is that my team are well aware that if they see anomalies in anything within the package or have questions, they will go back and question that to the command chain.
But it's the case, isn't it, that it very much falls upon the member, though, to identify if they have some well-being or mental health concern that has perhaps led to the behaviour, for them to come forward and identify that. Would you accept that?
Certainly that is part of it, but it is also then up to the command chain to understand and once again, it hasn't happened yet. Templates will be amended for involuntary cessations to include the COs then look at the possible causal factors, much the same as we do with notice of positive test results, possible causal factors, and that will be included in the ICSIN. So
that's presently not the case, if I can just understand. And when is that proposed to be amended?
ASAP. So we're currently going through a process of looking at all of our templates. The members' guide is being updated. We weren't in a position to give you finalised. We've been doing that periodically over the last 2 months. In terms of our capacity, we haven't finalised as yet.
Yes, thank you. Because would you accept that, to the extent if there is an underlying mental health concern or well-being concern, often there is some stigma that might attend the members' reticence in bringing that forward in this process? Might that be a factor that comes into play?
It could be. We really, as a commanding officer, as a previous commanding officer, and we really place a lot of responsibility on our COs to be responsible for the welfare and well-being of their members, and it's part of their command responsibility to identify that. We are explicit in that in our prohibited substance cases, and we're going to be explicit in that for COs to draw particular attention in their recommendation to anything that they think, thing that they need to draw our attention to around the members' welfare and well-being.
Yes.
There's a number of areas that we attempt to mitigate that through process in terms of Chief of the Army has directed all COs in CA 13 of 21 that everyone is to be afforded a support officer. The member can choose or can say no to a certain specific support officer, which then hopefully negates the fact that they can then open up to that support officer and and freely share information with them. Part of that responsibility is to then assist them with the statement of reasons. So I acknowledge the possible stigma. There's also, in terms of procedurally, as part of the process, which is further down the track, a transition health examination, which is done by the medical system in the main, which is outside of the chain of command. So should the member have possibly an issue with the chain of command or possibly have an issue with not wanting to share, well, then that's an external organisation that hopefully they can then feel free to share their issues with mental health, issues with even physical injuries or other issues. That will then, if sufficient enough, then initiate a CMECR and a MECRB, which will then go through another process, which will then subsequently hold in abeyance the involuntary cessation.
Yeah, but all of that occurs, of course, after the determination's been made as the involuntary separation.
Yes.
Let me take you, please, if I may, to notice to give DEF 016. It's in the tender bundle, and operator, I'll give you the reference. It's DEF dot. You're ahead of me, thank you. No, it's another one. Let me give you the reference number, DEF dot 9999.01030123. And whilst that's being brought up, that's it. And if I could ask you please to go to page 130, 0130. So you'll see down the bottom there, if I could ask you to, and unfortunately it runs over the page, so operator, if I could ask you to focus on the table 5.1 at the bottom and give the witnesses an opportunity to review that. Thank you. And then running over to the page is the rest of that table. Excellent, thank you very much. You'll see there that is a record of the total number of members whose service was terminated pursuant to 24.1c. and 24.1a, but we're only interested in 21c for these purposes. That's across all services, but I won't ask you to engage in the calculations, I'll do that for you, but you'll see in 2020 in respect of Army, and we'll just focus on Army, given your positions, 276 terminations. 2021, Army 163. 2022, Army 140, and 2023, Army 52. Adding those up, since 2020, there have been 631 early terminations under Section 24.1c. So we'll start there. Now, you mentioned earlier, Lieutenant Colonel Francis, that approximately 30% of the referrals, if I can put it in that way, from command are overturned or the termination are not terminated. Is that right?
So that's a relatively fair assessment in terms of that sometimes you will also then get an ICSIN from the unit that actually doesn't specify that they recommend. So based off the statement of reasons, CO may actually send it to CMA still as a delegate to then impose a lesser sanction. So roughly in 2021, 2022, 30% of all cases that we received were then retained.
Retained. So the
70%.
command decision was not upheld, put it that way.
I think in those
So
sometimes.
I object to that because the command decision that the last answer referred to didn't necessarily include separation.
Yeah. I have to forgive my friend, I didn't hear the last aspect of that.
Could you repeat that?
I'm sorry.
Mr. Ford?
The last answer had within it the suggestion that the command decision did not always include separation, because there was a reference to a lesser sanction.
Isn't that correct?
Yes, but the question that was asked presumed that all had recommended
Oh,
separation.
I see. Right. Do you want to rephrase the question, Ms. Rubagotti?
Or just by way of clarification, because I just want the issue that I'll come to is the number, the 30%. But if you go then to the reasons for the CMA decision, and that's in table 5. I can just take you to table 13.3 of this document. And that should, and if you can focus on that.
That's 11.
11.3. That's 11.3. We want 13.3. All right. Yes, and this table goes over the page as well. And I'll use the language of the table heading just to ensure that there's no misunderstanding. So you'll see here Army's occasions during the relevant period, the years indicated, that CMA determined that a member's service not be terminated pursuant to 24(1)(c) of the Defence Regulation, notwithstanding a recommendation that the member's service be terminated. And you'll see this is Army, so the number given there is 48. Is that where you derive the 30% from, or is it from some other?
So the 30% comes from our databases of all ins and outs.
Right. The reason I asked the question, because subsequent upon receiving this notice, we have also received a corrigendum that addresses, and I just want to make sure you're across that addresses that table. I'm sorry, you have to go over and display the bottom of the table, operator. That's not, this is the beginning of the table. There we go. That's the number I was after. 211. So that's why I wasn't sure the 30% was derived from this compared with the 631. We've since received a corrigendum to address this number. And in fact, when you look at terminations, if you go to the corrigendum now, DEF.999.0116.0002 at 0004. This indicates, when it's brought up, that in some 47 cases in the period from 2022 to 2023, there were 47 occasions in which the delegate in CMA Army did not terminate a member in Army where the CEO had recommended termination. And that's your understanding of that table, is that correct?
That's the documents that we provided for that answer.
Yes. So having regard to that, can you, and could be a misunderstanding on my part, so I'd be grateful for the explanation, the 30% to which you referred before, how does that relate to this figure? Perhaps you could just explain the matter again for me.
So the 30% was, as I said, from my databases that my team hold. So there's two separate pieces of data.
Mm-hmm.
This was DPG created. Ours was based off only 2022, 2021. a rough estimate of 30% retention, 70%. So it was never meant to be a data figure for you necessarily. It was more of an indication
I see.
that we retain approximately 30% out of all of the cases that we look at.
I
Didn't
understand.
take into consideration the CO's recommendation or not. That was just the delegate's final decision.
I understand. So this is a subset of the data we see here, is that right?
Correct. So the two may not necessarily be, if you look at zeros and ones, will not be necessarily fully aligned.
Okay, I understand. Referring now, so thank you for that, and putting that suite of data to one side. Referring now to this, we see here that on 47 occasions of the 631, it was determined by the delegate not to terminate the member. Is that correct?
Correct. So as I understand this, and the answer to the question was that the CEO recommended a separation. The CMA delegate decided on retain.
I see. Thank you.
So retention also then comes with all of the other admin sanctions available, be it formal warning, censure, reduction in rank.
Thank you. So with that background, it's pretty plain though that in the large majority of occasions, the command view was sustained. Is that correct?
Yes.
Yep. Might I ask you to comment on that? And does that say something to you about the nature of the process and the nature of the information you're receiving, or the nature of the issues that might be leading to terminations? If you can just if you any views reflecting on that.
I'm sorry, there's three concepts in that question that would have to be dealt with individually.
Let me. Do you have any views reflecting on that number?
Can you be a little bit more specific, please?
Well, does it suggest to you that there might be some inherent bias in the process towards the command view? And if not, why not?
I think in the first instance, the issuing of an ICSIN is not taken lightly. So I think a CO would, they place great weight on whether the issue of an ICSIN is appropriate. There are a number of circumstances where an ICSIN must be issued. So I think that would be the first thing that when it comes to CMA, it's been thoroughly considered. So I think that based on that, the members' mitigating circumstances taken into account, but it may have been that in all those cases, the actions, the delegate considered that it was appropriate for separation.
So I would echo that in terms of an ICSIN is not the first action from a CO, and nor should it be, because there is always the requirement to look after our soldiers, and not just this action happened, so therefore we're going to go directly to an ICSIN. So that ICSIN will then have it preceding that, and should be a large number of actions. The second part as well is we actually remove the decision-making process in terms of the opposing authority up to and make it centralised in CMA to remove that bias. Because otherwise the COs have to not only look the member in the eyes, they also then have to manage the decision. If it was down at their level, they would then have to manage the decision they make, which would then, I would suggest, add more bias. So by removing it up and centralising it, we're actually trying to remove that in terms of process. We're trying to remove that bias.
Nonetheless, does there remain a risk insofar as command is the conduit for the members' views? So command, that the commanding officer who's saying, I'm issuing you with a notice, you have to come to me and give me your reasons for why you shouldn't be terminated, etc. Do you think that nonetheless can retain a bias in favour of command? Do you have any view in relation to that?
I can follow your train of thought. However, once again, the statement of reasons supported by a support officer of the members choosing will hopefully be honest from their point of view. That's their ability to talk directly to, and I acknowledge the fact is what you're saying is that statement of reasons need to go through the CO. So I acknowledge that fact.
That's right.
Yeah, and the member also has, as well as a support officer, they've got access to a range of other services and support as well. So there's Padres and there's the Unit Health Centre and there's DMFS. So all those functions are available to the member as well.
Yes, and when it comes to the members being offered that support, am I correct in understanding what you said, but that again, that is mediated through the commanding officer, is that right?
It's generally probably not through the commanding officer, depending on what rank of the member. It could be their platoon sergeant, platoon commander, 2IC officer commanding, so it could be lower level depending on the rank.
But would you accept that ultimately it's the commanding officer who's responsible for the welfare and support of the member, notwithstanding there also being the initiating authority, is that right?
Yes, they're the initiating authority.
Do you consider that, and nonetheless, that in those circumstances they're still ultimately responsible for the well-being of the member?
Yes.
Do you consider in those circumstances that there might be a tension for the commanding officer in being the individual who wants to terminate the member, but then is nonetheless responsible for the member's welfare whilst that member remains in their unit or wherever they happen to be?
Hence the comment about we essentialise that decision making and remove it from the CO. You remove the emotion, you remove the, as in between the CO and the member, you remove the bias. So I think it's an overall then, so the delegate can then look at the information and the evidence provided, of which the statement of reasons from the member is absolutely part of it, in order to make an informed decision.
And it's the CO who's engaging with CMA in providing the information, but the member doesn't engage with CMA in any way. Is that right?
That's correct.
Do you think that is a problem and can perhaps lead to some sort of inherent bias in the way the system works?
So I think the question is implying that all COs are out to get their people, which is absolutely not the case.
I'm not suggesting that.
So the COs are best placed in terms of having the people underneath them that manage the member day to day, have an understanding of their home life. So their platoon commander or their platoon sergeant or their corporal should be fully aware of the member is having problems at home. The member is, has X, Y, and Z. All of that information is at the unit level. The CO is then the conduit between that member, whom they're required to look after, and send that to the CMA delegate.
If I could just make a comment on that interaction between the CO and CMA, it's generally transactional in that I've got this case, we're doing an ICSIN, we'll have the response. What else do you require from us? Am I meeting all the requirements? Can I use the templates? Those kinds of things. We don't have the discussion around the actual case and what we think and what we're going to do about it. That's why we keep ourselves separate. It's largely transactional, but the CO is a conduit and that he or she will be making sure that everything that the member has been issued, responded to, is packaged up and goes into CMA.
Thank you. Now, when it comes to the decision-making process, we obviously we saw that there were occasions on which CMA came to a different decision from the CO. And the decision is made by reference to the definition of not in service interest under Section 6, subsection 2 of the Defence Regulations. And we saw too that those various categories were pretty broad in their formulation, so behaviour and the like. Having regard to that I take it on the same facts, the CMA is able to reach a different conclusion from the CO. Do you have a view as to whether those categories are sufficient to guide the decision-making of the commanding officer, or whether there should be some more detail in the information, in the description of not in service interest?
I think it's sufficiently, and then I'll let the boss have a talk as well. I think it's sufficiently broad enough to enable people then to then have the flexibility to make a decision from that. That doesn't make any sense. In terms of, we use all the other parts of the decision-making process to then overlay as well. So the policy, the procedures, etc. We look at things like the Briginshaw principle, whether the actions or whether the evidence is sufficient enough to then warrant a separation. And if it's not, then possibly looked at lesser sanctions. So all of those areas in terms of, yes, I acknowledge performance is broad. However, if I only have a minor infraction in my performance, in terms of I get one below rank in my performance report for the year, that's not going to result in then a separation. What it will result in, as I previously said, all of the other aspects that are available to a CO to deal with performance, to deal with behaviours, whether it be as small as local counselling or formal counselling as well, all the way through to notice to show cause as to why a formal warning or a censure shouldn't be taken out, or a reduction in rank if you're not performing at rank. All of those actions should be taken prior to then a Nixon.
Yes. Councillor, my view would be is that there is a policy that supports the defence regulation. So there's Milperseman, which we've tendered, which expands on it a little bit more about the performance and behaviours. And then each service also has its own policy document, and Army does that through its ASIP. There's also the CDF has released a Commander's Guide to Discipline, which is very useful, and also the Chief of Army's released his guidance on good soldiering. During a pre-command as well, COs also have a 2-day, 2 days of that course is on discipline and administrative law, which is exceptionally useful. And it's also their professional competence and experience that goes into their decision-making around what constitutes not in the interests. And it's also obviously depend on the actions. In many cases, a fact-finding is done, which will then sort of find out what happened to support the CO in making decisions as to whether an ICSIN should be issued. In other circumstances, as we said before, there's reasons when there's a mandatory requirement to issue an ICSIN. And we have a range of behaviours from unacceptable behaviour, bullying, sexual assault, through to child pornography. So sometimes it's quite cut and dry.
Thank you. And when it comes to the role of CMA and the delegate's approach to considering the material before the delegate, you've mentioned the policies and procedures to which you have regard. Do you consider previous decisions, and in similar circumstances, do you have access to that sort of information as you might in a court to precedent? Or if not, why not? Could you talk to that issue?
So, as part of the admin process of building the pack, as I've already said, we will do a review of previous behavioural histories, certs, etc. That may or may not have an impact onto the final decision. I'm going to flick to the boss, sorry.
Thanks. I'll probably refer again to the GADMAN, the Good Administrative Decision Making's Guide, which we use to guide our decision making in terms of achieving some consistency in how we weight material, looking at reliability, relevance, credibility, and sufficiency in those kinds of areas. I think also by centralising the decisions in CMA means that you've generally got the same delegates making the decisions. Those delegates do change over on posting every 2 years, but there's a fairly robust handover period as part of that. And there's often a lot of complex case discussion as well. If we looked at the figures last year for involuntary separations, there are 140, so they're probably generally made by the same two delegates who will always be in the back of their mind knowing what cases they considered. Every case is taken on merit. There is often a similar circumstance but a different situation, so we always take that into consideration. So we don't have a precedence term in our policy. In order to prepare delegates as well coming into CMA, we do provide training. We do moderation training for them. We have legal briefings on administrative law. There's campus courses as part of induction training as well. So they're all the principles that we try to instill in the decision makers to ensure some consistency of decision making.
Thank you. And might you identify the policy, if there is one, that clearly sets out what each of those subcategories under Section 6.2 mean and how they might be applied by the individual delegate?
As in sort of performance behaviour, so that it's actually in Milperseman, and then in the ASIP, I'm not sure what number it is, but it does break it down a little bit further. And where it says performance, it will talk about things such as unacceptable behaviour, bullying, sexual assault as examples.
Yes, and that is by way of example, is that correct? And it's not meant to be an exhaustive characterisation of what 6.2 means.
Yep.
Thank you. And you mentioned there the question of rotations and the fact that obviously you rotate through CMA. But there's a handover of cases. Nonetheless, do you consider that by virtue of that process of rotation and postings, that this can impact on the capacity to determine matters and to exercise the powers the subject of the delegation? And let me give an example of how the impact might occur, because you don't build up over time a sense of how the sort of matters that are referred, how commanders are engaging with their members, and the sort of issues that are brought before CMA. Do you think that the rotation then can cause a problem?
We always try to achieve an offset, so the delegates change over at different times. So at all times, we've sort of got for 1 year a person who's been there previously who brings that experience from the previous year. The other thing we really need to make sure with our delegates is that we're looking after them as well. And we often find that 2 years is normally sufficient for them. Otherwise, day after day, they are looking at some cases which can affect their mental health and wellbeing as well. So we try to keep it for 2 years, ensuring that we look after them and provide them support as well. But I understand what you're saying in terms of consistency over time.
Mitigate it as much as we can through things like face-to-face handover takeover. So, for example, at the start of the end of last year, I was lucky enough to be within the Canberra region, so I spent as much time with my counterpart that I was taking over from as possible, taking me through all of the processes and procedures, taking me through the thought processes, taking me through the strategic risk, taking me through the strategic thresholds that he was aware of. We then do induction training. We do mandatory training at the start of the year as well. So mandatory training talks to things like, suicide awareness, unacceptable behaviour. Defence does that. Induction training is really CMA specific, where we narrow in on your job and then do briefings. The delegate training, as the boss already mentioned, talked specifically to, for this year, specifically to MECRB and Invol SEPS delegates in how we do business in order to then ensure we try and get a consistent approach.
Yeah. And in fact, for next year, my staff for next year are attending IGADF administrative law training in October.
I see. Thank you. And an aspect of this too involves the assessment of the credibility of evidence and differing perspectives perhaps on the same evidence. What is the nature of the training that you undertake in order to be able to engage in that task?
There's no additional training to what we've previously specified, and that what you're sort of talking about there is the sort of discussions that we would have is when we do that decision-making principles training and those sorts of things.
Thank you.
So the members that are delegates are at a rank level and a maturity level within service that should have exposed them then to an array of areas. Part of their job role, they're being picked to fill that job role purely because of their time in rank, purely because of their rank level, purely because of their previous postings, their ability to remain human focused and not policy focused. So we get the ability through, for certain postings, to almost handpick our people to a certain degree within limits. So all of those are mitigating those factors.
And tell me, when it comes to a point, the cast of delegates that you have to undertake this process, are you not subject to the same workforce shortages or issues that have affected other aspects of the services, or do you nonetheless have workforce shortages that you need to manage?
So in Pete's area, we've got, besides Pete, who heads it up, there's 2 delegates. So unfortunately, there isn't a cast of delegates. There's 2, John and Phil. And I'm a warrant officer who supports them with a prohibited substance testing. And then we've got a warrant officer and a corporal who's only recently started, commenced to conduct all the administrative support for the cell. So we don't have the same workforce pressures. We don't have vacancies at the moment. And that's because last year the DG had specified those roles as being priority roles for fill within CMA.
I see, thank you. Now, when it comes to, once you've made the decision, the member's notified. How does that happen?
Through the CO.
So it goes back through, so you don't, do CMA separately contact the member?
Sorry, no. So once again, all by paperwork, documentation, the decision is written, formalised, signed, sent to the CO. We back that up with an email to the CO, which sort of specifies or sort of covers off on the areas of, to ensure that we are acknowledged that it is a stressful time in someone's life. So we have little, caveats, I suppose, in terms of we try not to provide bad advice on a Friday. That then, covers us for, over the weekend, so someone's not stewing over bad news on the weekend, and we can provide support to that member through the workplace. The email talks to the levels, the other areas of advice or policy that the CO may wish to look at if he or she has not appraised himself of that. I apologise. So yes, to the CO. The reason we get the CO to brief it is because a face-to-face brief is obviously essential given something of such importance. To text message someone you're getting separated from defence, probably not the right idea.
But and when it comes to the CO delivering that information, do you think that they're, and noting that it can be an overwhelming time for the member, can that create an additional tension and difficulty and pressure for the member, given that the person who's initiated the termination is the one who's also confirming the decision that's come from CMA? Do you have a view about that?
Once again, the CO is there and he has a responsibility to those soldiers. So him or her being the briefing authority or briefing member, I think is appropriate because they're required to know the member and support the member. They're the ones that have had the been ordered to provide support officers, ensure the welfare, etc., etc.
Time frames. how long does the process usually take? Is there a policy that stipulates it all needs to be finished within a certain number of weeks, or is it guided by something else?
Policy talks about once an ICSIN has been issued, the member has 14 days to respond, and then it gets sent to CMA, and there's a 28-day time frame in there. We try to keep that under that. Sometimes it does extend if there is some sort of going back and forth with the unit. Maybe the ICSIN lacks some detail, or if there's any concerns, but that's the time frame, and then the member is provided with the response.
So when you said, just for clarification, the 28-day time frame is for CMA to make the decision upon receiving the information from command. Is that correct? Thank you. And which policy sets that out?
It's actually Army Transition Manual.
So that's the Army Transition Manual. Do you know, and you may not, whether that time frame applies to the other services, to Navy and Air Force?
If it's in the Army, did I say the Army Transition Manual? I meant the ADF Transition Manual, my correction.
Thank you. So it applies to tri-service basis. Thank you. Do you, as to that time frame, is it a mandatory requirement that it be met? Or will there be occasions when you will need to take additional time in considering the material before you?
So I think it's a guideline that we need to try and achieve. Time is of the essence throughout any of these decisions, because as we've already previously stated, it's quite a stressful time in someone's life. So therefore, we not only try and get a decision out as quickly as possible, but we also then measure that with taking the time to make the right decision. So if taking the time to make the right decision means we need to go back and seek more information from the member through the CO for their statement of reasons, or confirming facts, or if we then have the requirement to do additional procedural fairness, that will all add time. So I suppose the answer is the gold standard is 28 days, and that can probably be achieved for 70%, 80%. I can't pick a number, I apologise. Of the simpler, less complex cases.
Might you give me an example of a complex case where the time frame might extend beyond the 28 days?
Yeah, so as the examples I've previously given, I suppose, in terms of the questions of fact for the statement of reasons, any anomalies provided where perhaps the member in their statement of reasons has alluded to something that they may not be getting procedural fairness. They may, maybe feeling pressured to give certain things. Any anomalies where all of the organisations or all the inputs that we get into the process don't necessarily align.
And tell me, are there any challenges that CMA faces in meeting that deadline? Presumably this is not the only task you have. Do you have other workforce pressures upon you as delegates that can mean that you don't always meet that deadline with all the best intentions?
So I think the choke point for most of the delegate decisions within CMA that I'm in charge of, the choke point is the delegate. It's not the administration process necessarily. It's not anything else. It's the number of delegates we have. In order to make the volume, sorry.
Yeah, and sometimes what can affect that is there are other roles which we would like them to do around continual improvement, looking at our policies, templates, guides, and also analysis as well. So that has an impact on their ability to do that.
Yeah, so there are pressures on delegates that can inhibit good and timely decision making. Would you accept that?
Absolutely.
Yeah. And then, what is the process then that is going on for both the CO and the member whilst the decision is in train? Is the member still in the unit? What is the position there?
Yeah, the member will still be in the unit. If there are issues, so the Chief of Armies has a directive on actions for commanding officers when conducting administrative or discipline activities, which is, I think, 13 of 21. And in there it talks about a range of interim actions that a CO can take. So sometimes the member may ask or be moved to another workplace, depending on what the issue is. If there's an issue with unacceptable behaviour and they're the respondent, we may need to separate two people in a workplace. So they could be moved to a different part of a unit. Another unit could take them on. So there's a range of different circumstances. They may stay in the unit. Sometimes it's not in their best interest or someone else's for them to stay. So,
Thank you. And then keeping in mind now the 47, the example to which we referred for, where the CMA decided that no, the retention of the member ought to be retained. What happens then? Do they go back into the unit, or do the same sort of issues apply?
Case by case basis,
Yes.
I think is the answer in terms of we need to understand the context of the case. Does it surround UB? Does it surround anything else where we may need to then, or not necessarily we as a delegate for this decision, but CMA writ large might need to then look at perhaps a separation of personnel. There's absolutely case by case basis where we'll then need to then call in other parts of the organisation, perhaps as in the career managers downstairs, or seek support through the medical system, perhaps for certain cases. But it's not a one size fits all.
And the member themselves also can initiate a request for a posting through their careers advisor or through their support officer.
Because the issue is not just for the member; it's for the commanding officer as well. You'd accept that? And then CMA has a role, as I understand what you've said, to play in managing that.
We wouldn't.
No.
We wouldn't, but if we felt that there was a reason or the unit approached us, that's when we would bring in the other career management agencies, whether it's front office or a soldier, and look at what needs to happen for that member.
Yes, and that's what I want to ascertain. It is through the career management agency, but not through the delegates where that is managed.
Correct.
Thank you. Now, returning then to a member, we've said that that we've identified that being on the receiving end of such a notice is a stressful time for members, and you've identified some of the supports that are offered to members, and you've identified that those supports are provided through the commanding officer, but also other members, I take it, within the unit.
Yes, their chain of command. Yep.
Through the chain of command, that's right. Do you have any view, and you may have already expressed it, but just by way of clarification, as to whether CMA in any way should be involved in providing support for the member, or even alternatively for the relevant commanding officer, but whether CMA ought to have a role to play there?
I don't see the delegate in having a role in providing support to the member or the allocation of their support officer. The management and welfare of a member is a unit responsibility, and whilst the CIO has overall responsibility, it may be the OC that they're dealing predominantly with. I don't know what impact, what benefit it would have for the delegate to be involved in the provision of a support officer to the member.
So the involvement I see for CMA, as in, I'll stop saying CMA, as in the delegate in my organisation, for the CEO and subsequently the member, is an education and assistance piece. Because once again, you don't know what you don't know. So if a CEO currently needs to understand a massive requirement of things to cover all areas, they can't necessarily be across everything. Part of my role is I'm supposed to be the subject matter expert in this. So my role is to assist the CEO and subsequently the member through the CEO in terms of all of the aspects, in terms of policy, in terms of possible support mechanisms outside that they may not have thought about. So we do offer that in terms of, at the start of this year, we went on a command engagement tour where I went and briefed all of my areas of responsibility and offered, commanders to have education and assistance as well. And I whether it be stupid or not, provided my personal phone number to all CEOs on an email that we sent out with all of the links and assistance. And I offer that to all CEOs to say, should you need assistance or should you need a further understanding of this process or how to do business, please ring.
And when it comes to the welfare of the member and also potentially the CEO through the process, does the CMA, do the delegates routinely reach out or make inquiries of the member or the CEO in respect of health and well-being, mental health and well-being concerns, or no?
No.
Now, if considering the topic of command referrals, have you identified any challenges or issues that have arisen in command initiation of proposed terminations? In the way the matter has come up to you, in any anomalies? You've mentioned anomalies. If you have, could you speak to that?
So, as I just previously mentioned as well, I sent out an email that came with it some information from the subject matter experts in the majority, because I was new at the start of the year. I got it from my SO2 level delegates, and we basically provided tips to young players. Some of the common faults were, as previously discussed as well, under admin law and procedural fairness, in terms of the CEO making a recommendation and bringing up new evidence or new information in that, without then possibly sending it back through the member. So that I have not seen that this year. However, the fact that it made the email, there was obviously instances of it last year.
Thank you. And might I ask, operator, if you were to bring up, please, document DEF.1220.0001.0071. This is the Commander's Guide on Delegation. Now then, operator, might I ask you, please, to go to 0084. And if you could focus on that. You'll see that there's a heading, CMA Observed Areas for Improvement. It might be helpful, just by way of context, to go to the previous page, potentially. So these are issues or areas for improvement that CMA has observed for the purpose in the way the command manages terminations. I'll return now to the page to which I referred previously, 0084. And if you can just focus on that, I'd be grateful. And consistently with some of the issues that you mentioned before, we have here a list of problems that have been identified, presumably, in the course of referrals. There are a number, and they do pick up on some of the matters you've raised before about procedural fairness and how matters are referred up and whether they ought to be referred up. Is the training, this manual in the first instance, and the training that you've identified and the matters that you'd identified earlier, is that the extent of information that is provided to commanding officers in order to guide them in undertaking the termination process or commencing the termination process? If there are other things, what are they? How are commanders otherwise guided?
So we have the overarching policy as well. So this guide has been produced from policy, and again, as Pete explained earlier, this is from last year and is currently being updated to make sure it stays relevant and contemporary. So they've got guidance in MilPersMan and the ASI. Also, our website has a fair bit of information on it. They've got open lines of communication to the delegates in CMA, And they've also received their 2 days of administrative law training on their pre-command course, which I understand is still occurring.
Thank you.
I suppose I'd add to that as well. We have specific training on the pre-command course. So prior to becoming a CO, you'll do some specific training. You also then have experience. So as part of your career progression, particularly in the officer realm and the senior NCOs, you will go through a period where you are either providing advice to the CO or formulating or creating some of these documents for the CO, which means you will then have experience in it to then make a better informed decision. Not a decision, sorry, a better informed outcome.
But like all decision-making processes, nonetheless, there are issues that can attend at the command level decision-making process, and then that's something that CMA takes into account in the course of making its decision. Is that right?
Sorry, say again that question.
Yeah.
I'll rephrase that. This document does tend to suggest that there are issues that can attend the command decision-making process. So a failure to grant procedural fairness, a failure to obtain relevant, reliable and credible information. Is that the issues that are identified here, issues that the CMA process endeavours to consider and take into account or identify in the course of making a determination?
Yes. It's because it's applying the principles of administrative decision-making, yes.
And then once CMA has made a decision, is there an avenue available for the member to contest that decision? If so, what is it? No.
Yep,
Would you speak to that?
It's a redress of grievance, which is specified in the CALM. I can't remember the exact chapter. But the end state is the member has a right of reply during the whole process. So statement of reasons as in terms of the notice portion, and in terms of post decision, the redress of grievance is then the avenue provided to the member to then provide their grievance for that.
Thank you. And Commissioners, as to the question of redress of grievance, that is set out in detail in the Defence Regulations of 2016, and in particular in Part 7 of those regulations, and I trust you're familiar with the provisions set out there. Having regard to those provisions, would you explain, please, to the Commissioners how the process works? To whom is the complaint addressed? How is it managed, to the extent you know that?
So once again, it starts off with the member initiating it. So I'll start one step back. Decision is made and briefed to the member. The member then has the avenue of a redress of grievance. They formulate that within a specified time period, which is 14 days post-decision. They will then submit that through to the CO. The CO will then review that and identify whether it has merit. If it has merit, the CO will then contact CMA and the delegate and inform them that they feel the redress of grievance has merit for the following reasons. The delegate will then review the decision based off possibly new information in the redress of grievance to then look at it holistically and go, does this change the decision? Have they provided sufficient evidence in order to then, when you look at it then holistically from the start, setting aside the decision, looking at it holistically from the start, does it change the decision? If the answer is yes, that assessment will be made and an action will be taken to then, in accordance with whatever decision is made.
If I could just pause you there,
Certainly.
to understand that. So that we're still at the CMA stage here, is that correct? And when it comes to the redress of grievance after CMA has made the decision and the member communicates the further position to the commanding officer, is is there a mandatory obligation on the commanding officer to refer that to CMA, or again, is there a discretion that attends the commanding officer's decision there?
It's a discretionary thing. However, at the same time, I'm pretty sure it's legislated that that it's then CC'd to IJDF, which is in essence is a catch-all. That should the CO go no, so to follow that on as well, if the CO then finds no merit, it is then automatically then sent to for IJDF for action.
And then, are you able to explain it? I should just pause here just to mention, Commissioners, of course, we're going to hear later in the week from the Director of Military Redress and Review, and that will be on Friday, regarding the redressive grievance process. Now, in that connection, on the 19th of June of this year, the Commission issued the Inspector General of the Australian Defence Force with a notice to give information in respect of the redress of grievance process. Now, in what is identified, and of course, and what is also reflected in the legislation, is that among the complaints that can be referred to the IGADF pursuant to the defence regulations are a decision to terminate a member's service pursuant to section 24.1a or 24.1c, I should say, as we have in mind here. And then when that referral takes place, what is the information that is provided to the IGADF? I'll ask that question first.
Sorry, is it?
There's 3 different forms that have to be filled out for a ROG. One of them goes to IGADF and it has all the details on it. We've had 2 cases this year where members submitted ROGs that went to IGADF last year, that went to IGADF this year on decisions from last year. So we've received those. So we've got to have experience in receiving 2 of those where IGADF found some adverse findings against the processes that were utilised last year, and they make recommendations about that decision making.
Yeah, and tell me, those redressive grievances, do they go through the commanding officer to IGADF, or do they go through the delegate?
No, so key to note is that if the CO, commanding officer, does not find merit in the redressive grievance, it does not come to CMA. It goes to IJDF.
Yep.
So we would not be aware that a ROG has been submitted.
Yeah, thank you. And in terms of the redressive grievance member complaints that have gone to IGADF, and might be picking on something just identified there, it's fair. The Commission has reviewed certain of those complaints. And a number of systemic issues or process issues are identified, at least by members, and been picked up. And they are these, so I'll identify them and ask you to comment on each of them. So the first is that the time allocated to provide a written statement of reasons is too short, so the 14 days. And I know you mentioned that there's a possibility for an extension of time, but nonetheless, that has been raised. Going back to that question of the 14 days and the time allocated, it's the case, isn't it, that within that period, a member might wish to obtain legal advice. That can take time. Do you consider that the 14 days is adequate to enable the member sufficient time in order to deal with what is a very significant issue within their career?
So I would suggest that the 14 days is legislated, but it's also then you can provide an extension to it. So there is a process there where that's mitigated.
Yeah, I wouldn't provide comment on the 14 days whether it's sufficient from a member's perspective. If they consider it's not sufficient, then that's their view.
Do you consider that the question of the 14 days, notwithstanding the fact that you can get an extension, and that ticking clock can be an additional stressor for the member in the circumstances under consideration, that their career is potentially subject to termination?
I would agree with that premise that absolutely it provides a time which provides pressure.
Do you consider that, notwithstanding the fact that there presently is that discretion to extend, there should be a requirement in the legislation for a lengthier period of time in order to respond in the circumstances?
So not owning the process in terms of an ROG, I can agree with your premise, but I don't own the process in terms of particularly. It's outside of my remit.
In terms of the 14 days, given that within the redress of grievances, the question of the 14 days in order for the member to respond to command has been raised as an issue.
Is there redress of grievance or statement of reasons? Then, sorry, Councillor. The 14 days we're taking to provide a statement of reasons?
To provide the statement of reasons, that has been identified within redress of grievance as an issue.
Yep.
So I'd clarify that. And so that initial 14 days to provide a statement of reasons has been identified as a problem. Do you think that there will be a benefit, both to the member command and also to CMA, if a lengthier time were given to the member, not by extension, but by mandatory obligation?
I couldn't comment. If members feel that 14 days isn't sufficient, then I'd suggest it's not sufficient. It wouldn't affect us because we get the pack when we get the pack. I think all it does is delays the time frame for the member to be thinking about it for 28 days instead of 14. But if it's an overwhelming member's perception, then that's the perception, yeah.
Another issue that has been identified in through the redress of grievance process is that again, turning to timing, there have been complaints about separation dates and they're being too close to the commencement of the process, and members not being ready for their separation from the Defence Force. Are you able to comment on whether, first, is a separation date mandated? Is there a period of time in which the member must be separated?
It's a 90-day period. So and that's been increased from 14 days. A few years ago it was 14 days. It's now been increased to 90. If I can just step back to the first question, just to follow up on what you were asking about the 14 days, is another separate involuntary separation is a termination due to a notice of positive test result. And under the Defence Act, it's legislated the members should have a minimum of 28 days. So there's some policy there. Your second question about the time for separation. So at the moment, not in the interest, involuntary separation is 90 days. Again, that can be extended. The delegate for that is the delegate that made the decision, so that's us in CMA. If we are advised by the unit that there are circumstances around their transition that aren't going well, then we can extend that date. We have to really carefully manage the member and their wellbeing and that of their family, but also that of the team and their unit that they're in and the impact on them and their morale and wellbeing, especially if they're required to deploy or be in an arduous environment, what that means to have that member still there, and also the impact on the organisation, that is Army, Defence, to deliver on its capability, but also what government and community expect of us. So it is always a tension.
Another issue that has been identified through the redress of grievance process is that the PM 006 and PM 008, which I understand refers to the psychological reports, is that correct? That they are often used against a member. Having put that proposition, do you consider that as a delegate, a CMA delegate, you would benefit from independent psychological reports. Do you have a view on that?
Independent, as in a psychologist from outside?
Yes.
So, yeah,
I'm sure, I think there's a degree of organisational assessment around that a military psychologist provides. That's all I'd probably sort of comment on that one.
So I just want to clarify, in terms of a PS 006 that says organisationally unfit for service.
Yes.
Is not a mental health, is not a clinical condition. That is not what we're talking about here. That the clinical condition is a medical MECRB issue to deal with, and then should be looked at as a medical separation, possibly. Mm-hmm. The organisationally unfit is literally that, in terms of you don't have the aptitude, perhaps the learning ability, the ability to do a job in defence, or your attributes severely undermine the values, the behavioural aspects required for you to do your job in defence. It is not a medical clinical decision. So we just need to separate those two.
In those circumstances, then, do you think there will be benefit for CMA to have access to an independent organisational psychologist report or something as to the members' conduct, behaviour and fitness for defence?
So I would have to defer to the psychologist on this one in terms of the specific clinical advice given, but we have the appropriate members in defence who understand defence, who understand the requirements from defence, who understand the aptitudes and the traits, if that's the right word, to be in defence. So perhaps an external organisation may not be able to achieve that. I'm not too sure.
Yeah, I think a military psychologist brings the organisational suitability, understanding and experience with their assessment.
Thank you. And then another issue that has been raised, separate from those issues, is that termination decisions are often perceived as being disproportionate to the circumstances giving rise to them. So with that idea in mind, to what extent are alternative sanctions considered? Probably at two stages. You've mentioned command, but also is there any remittal within CMA to consider an alternative sanction? And if so, can you speak to that?
Yes, it's quite often reviewed in terms of the credibility, reliability of the information available. I've already talked about the Briginshaw principle, and for all the legal people out there, I might be utilising it slightly incorrectly, but the evidence needs to match the punishment to a certain degree. So we look at all of that, and if we also then look at the situation and context holistically, in terms of what is the juice worth the squeeze? Is the punishment worth the crime? So we will look at all of that. We will also look at holistically was this a one-off? And is the one-off that extreme that warrants separation, or is the one-off exactly that, a one-off, where the member can be rehabilitated, likely to then learn from their lesson, and then later on become the best soldier in army. So we look at all of that and take that into consideration, which is I won't say often, which is why we will then sometimes go against the CEO's recommendation of separate, because we look at it then holistically, plus utilising all the strategic factors we've already talked about in order to make a decision for Army, not necessarily a decision for the unit where it's been initiated from.
And our team's decisions are also reviewed by our legal officer as well, so we've got that additional overlay.
Thank you. And where you mentioned there that you do sometimes CMA does sometimes make a decision that doesn't conform with that made by the commanding officer. And nonetheless, it has been identified through the redress of grievance process that members have identified an inherent bias in decision making and have identified power imbalances on the one hand between the initiating authority and the imposing authority, and on the other hand, the member. Now, we've addressed this a little bit. Nonetheless, given that that has been identified in the redress of grievance process, is there anything that you might suggest as a delegated authority that could mitigate that issue, whether by way of perception or fact?
Can I ask for clarification on the power imbalance you are referring to?
It's being the fact that the referral of the member's proposed termination and the provision of the information all goes through command. The communication then goes back from CMA to command, and the member is outside that process because there's no separate engagement with the member by a CMA.
Yep. So once again, I suppose that's there is a reason why we are the delegate function and the decision function and not the face-to-face. The reasoning behind that is to try and mitigate bias, try and mitigate so many variances in decision. If we were, for an example, I don't know how many commanding officers are in Army, but let's call it 50. Instead of having 2 delegates, we would then have 50 delegates, which would then have a variance. So we try and centralise that in the CMA. And I'm not here to say this is the best method, but it's the method we're using at the moment, and it seems to be working okay.
But nonetheless, at the end of the day, your communication is with command, and there is no countervailing communication directly with the member. That's right. Yeah. And might there be a benefit in your being able to communicate with the member as well?
I think if you're looking at some type of other neutral person, I think it would need to be someone other than the delegate. Yep.
Can I just refer matter I overlooked before, when just on the question of the 14 days and its appropriateness or otherwise, in the information that's been provided under the notice to produce, and I'll just refer operator to DEF.9999.0103 at 0123 at 0134. This is table 5.5. Once it's displayed, what it will show to you is that focus there on table 5.5. And this is the members whose service was terminated pursuant to 24(1)(c) and submitted a written response. If you have a look, have regard to the numbers shown there, so in 2020, 101, 2022, I'm just focusing on Army here, 53, sorry, withdraw that, 2021, 53, 2022, 51, and 2023, 23. And we have in mind that figure of 631. It will be apparent from this that the number of people who put in a response is less than 50%.
Yes, we looked at those stats.
Yeah. Yep. Do you have any view as to whether, or might that suggest that the time allocated for members to respond is insufficient?
We would have compared those to the numbers where the member is elected to not make a response.
So those numbers say that there's less members that are wanting to put a statement of reasons in or who submit a statement of reasons. That can be many different factors. Often member will go, some will say, it'll range from, some will say, I want to get out of defence, so why would I put a statement of reasons in? Others may well be, there may be a few occasions where they felt they didn't have the time and they just gave up. There is many different individual reasons in those figures that I just can't define for you.
Elaborate on. Thank you.
I think what that suggests to me is that they're the members who chose not to make a response. If we do receive a pack where a member has elected to make a response and that response isn't in there, we will then reach back to the unit to ask where it is, because the member has made a decision to put a response in. So they would be the ones where the member is elected to not make a response. And it could be a variety of different reasons why they've done that.
Thank you. Now, returning then to the redress of grievance process. Excuse me for a minute. Returning to the redress of grievance process, there are circumstances when a decision of CMA or a different decision is taken from that decision of CMA in respect of the termination of a member through the redress of grievance process that goes up to IGADF. Is that correct?
So what will happen is IGADF will make a recommendation, so they don't make a decision. They'll make a recommendation on that ROG. As I said, this year we've received 2 of those, where this IGADF made some recommendations that were adverse to the outcome. And in both circumstances, we took on IGADF's recommendations and reinstated both members. It was based on process.
And tell me, when it comes to considering the recommendations from IGADF, is it the case that there is a discretion to not, as you say, take on board the recommendations or to take them on board? Is that right?
There's discretion to accept them or not. We accepted both, and we made the decision to reinstate both members.
Yes. And in terms of that decision-making process, does it follow the same? What information do you take into account? Do you go back to command? Do you go back to the member, or do you just consider the recommendation as given by IGADF together with the existing information?
We consider the recommendations in the IGADF report. It's normally quite lengthy with all their considerations, and so that's what we take into account.
I think that highlights the fact that the delegates will always work on the information provided, which is why we absolutely, any chance we get, try and educate people to say whether you're the member that the action's been taken out on, or whether you're the CEO or anything else like that, put as much information as we can into the process to then enable an informed decision.
And thank you. And when it comes to IGADF's consideration of the CMA recommendations, do you receive feedback in respect of your own processes from IGADF, or no?
So in both the circumstances, we understood why they'd made those recommendations, and so based on that, we had a look at what happened in both of those circumstances, and we discussed it. And it's not that we had to change anything, but there was I won't talk to these specifics, but there was just both a procedural error made in both cases.
So then the feedback that is received is generally contained within the report that you receive from IGADF and not separately provided, is that right?
Yeah, it's part of their statement of reasons, I suppose, as to their recommendation and how they came to that recommendation.
Yeah, thank you. Just excuse me for a moment. No further questions at the moment, Commissioners.
Thank you. Commissioner Brown.
Thank you very much. Can I just ask, in relation to where a member is providing a statement of reasons and they have the opportunity to put forward circumstances that might be impacting on their performance or their actions or behaviour, what we've heard, I guess, over the course of our inquiries is that there are circumstances where a member may be suffering, for example, from PTSD or major depression, anxiety, which they themselves don't actually recognise or acknowledge, but it comes out in the form of perhaps drinking too much, standards slipping a bit more risk-taking. So they wouldn't include that in a statement of reasons. And it's entirely possible that their CO might not recognise it either. So how do you safeguard against that kind of circumstance?
One of our, thanks Commissioner, one of our, I guess a catch-all is that members who, there is a principle that's being put into policy that a member who is being involuntarily separated and at their transition health exam or their THE, when there's assessment done on their mental and physical health, if they're considered to be an S7, which is it's a higher rating for mental health, they're referred immediately to what we call a CMECR, which is a Central Military Employment Category Review at the health centre. So their separation is paused while they go through that, and then we consider whether they need to go through the MECRB process.
But who would actually recognise that? Because they might just be sent as being organisationally not fit. They may have had multiple small, administrative kind of charges around not, failing to meet standards or smoking where they shouldn't or, uniform not having the right creases or, whatever the accounts are. And we've heard multiple of those. So they're not necessarily going to get to a medical or a health assessment, are they?
I guess it depends whether the medical assessing officer assesses that to be the case. How much is showing? I'm not sure.
So Commissioner, I would add that the THE, which is the process, is owned by Joint Health Command. So without talking on their behalf, my assumption is that the questions asked as part of the questionnaire format. So a THE will take it'll be 60 minutes minimum. And if you have to do a DM42, which is a CSE form, it will then be for an hour and a half is what I'm led to believe. So as part of the process for that, my assumption is that those causal factors should trigger. But once again, I can't talk with any authority on that.
Yeah, and again, I can only go on what we have been told, and it's a smallish cohort, I guess, overall. But for example, I've had people say to me, I went to my medical examination prior to discharge, and they said, "You don't have any mental health problems, do you?" Tick. So how you frame the question is going to very much influence the answer you get. And this is after someone potentially has been found by CMA to warrant termination. They go to their health examination, and it may not be a large cohort, but I'm just wondering, how do you build the safeguards in against the people who don't necessarily recognise they've got issues, but their behavioural performance is being impacted by those issues?
I guess that's the thing, is that the commanders are not well positioned, may not be well positioned to do that.
No.
Because they may not recognise those causal factors. The medical professionals are the best organisation we've got to identify that.
But they're under the pump as well.
Absolutely.
Commissioner, it can be really tough. And that's why we want to sort of put into our considerations for COs and members when we update our statement of reasons and the guide, is to really have the member and the CO think about it and actually make comment about a member's health and wellbeing.
Yeah, I think that's really important to have that kind of curiosity as to what's going on here, and not just assume that it's, poor performance, poor behaviour.
And that's a simple update to our template, which absolutely we will do.
Another question, Council was asking you about, and had indeed the numbers of the percentage of service members who choose not to provide a statement of reasons, and you said that there may be a whole host of reasons why. Has CMA ever actually gone to service members in that circumstance and asked them why they didn't? Again, as an aggregate kind of survey.
Thanks, Commissioner. It was interesting getting those stats because it's not something that we regularly analyse, and we're discussing before just not having the staff capacity to do that trend analysis hasn't permitted us to do that, but seeing those statistics is really interesting. And I think in the first instance, when we have a look at how many members actually aren't submitting a statement of reasons is concerning. And whilst they may be making that decision not to, I think it would be really valuable to be going back to understand why they don't want to.
I mean, I've got a few questions here which are essentially all under the heading of quality assurance, I guess. Another one is in relation to, you know, you talked about the consistency of your decision-making by your delegates, and that's helped by all the training and things you listed and by the fact that you've only got a couple of them. But do you actually have a quality assurance process that checks the consistency? You've assumed that it's pretty good, but how do you know?
I guess that's what makes delegate decisions really tough. We do have the one legal officer who reviews all of our cases, but in terms of a quality assurance, in terms of checking the quality of the decision, that's a tough one.
Can I won't go through all of these. Can I ask, does the delegate ever consider the suicide risk when they are, well, the risk of suicide of, you know, we know from the statistics that the risk of suicide is elevated in those who are subject to an involuntary separation, as Council said at the beginning. Is that ever considered in the process? And if so, how?
I'll let you talk this as well, Pete, but I guess from, sorry, I'll hand over to you in a minute. It's the decision to separate someone, and whilst I haven't done it under under the involuntary, not in the interest, I have under Defence Act for prohibited substances. It's certainly not a decision that we take lightly. I've reviewed a number of cases where we've seen a couple of red flags on people. A separation decision is being made, and we can see that there's things lining up for that member. Including whether they might have a debt when they separate due to having received a bonus. And in those cases, we have talked about them and to understand what we need to do to mitigate what might, their separation, to delay it, to avoid a debt, those kinds of things. Did you want to say?
Yes, I guess, Commissioner, the team are well aware of the heightened risk to members in this bracket. Or this cohort. As such, it is taken into account, but once again, it is only, you talked about being inquisitive, curious about the decision. I'm lucky enough to have two people that are curious about the decision and will ask questions of COs. If they find anything that will flag, which is great, but the problem then is, as you've already alluded to, if it's hidden and it doesn't present, making a decision being aware that they're in a heightened group, if there's no flags, to be quite honest, we've got to take it on face value and then, as I said, hope that the professionals and medical professionals will then catch it at the transition health examination.
I don't mean to put you in the spot, and I acknowledge that you've both only been in the role from the beginning of the year, but do you actually know how many suicides there have been of people who have separated involuntarily since 2003?
I don't.
No.
It is in the published data.
No, I know it's 3 times as likely for a veteran who's been involuntarily separated.
Yeah, so the 96 is what the AIHW report tells us. I guess my question to you is, has CMA, and I'm, again, not necessarily you two specifically, but has the CMA ever done a look back to understand people who've been through this process, terminated involuntarily, and who subsequently went on to suicide?
Not that I'm aware of, Commissioner.
Is that something that could be done?
I would suggest absolutely, but I'm not entirely sure whether CMA would be the organisation to do that.
Maybe the organisation to initiate it, though.
Sure.
A couple of other quality questions. Does CMA ever look at the COs who are referring for administrative termination and whether there's any over-representation of COs or particular units who are funneling more people in for administrative termination?
So in terms of trend analysis, as the boss said, in terms of a capacity issue, we do not do trend analysis. By virtue of only having two delegates, they will naturally assess that as the volume coming in. Have we noticed anything this year or last year? No. However, I'm aware of times in the past when a certain unit will definitely flag to CMA or even Army headquarters perhaps for different reasons. Those units will then be, if they're flagged, will then be assessed through other avenues, but not my delegation avenues, if that makes sense.
And then I guess that was going to be my other question was, is there any cross-referencing between, because as you said, you don't have the resources to do it, but is there any other cross-referencing? For example, I don't know, the surveys that get done or whatever, unacceptable behaviour stats. I appreciate this is often a manpower issue, but it's people's careers and people's lives. So it's trying to understand what level of safeguarding is in the system.
Yep.
Commissioner, can I just ask about the overseers representation? Is that through what they say in their recommendation or engagement into CMA outside of the process?
Sorry.
Just when you're talking about over-representation by the CO, did you mean that in their recommendation is overly biased or actually is reaching into CMA outside the process?
And I was wondering whether you look for any potential bias.
Of more ICSINs coming from a certain unit, for example. Yeah. Because we had the two delegates, that would be something that they would recognise, but it's not a trend that we.
Sorry, just so I understand, but those two delegates change every couple of years too, don't they? So then
Yes,
they're not necessarily
no.
going to.
And the COs change every 2 years as well.
I know, but the COs come in and out of command posting, so they are going to have more than one bite at the cherry, whereas your delegates are probably not. When I say one bite at the cherry, they're going to be in command positions on multiple occasions, potentially. And look, just the last question. You talked about CMA actually being fortunate to be prioritised and have your positions filled, and I just want to understand, is that because of the small number of positions you have, or is that because of the nature of the function you provide, or is it both?
It's probably both, Commissioner. Yeah.
Okay, thank you.
Thank you.
Commissioner Douglas.
Thanks. Thanks for your assistance too. Could we bring up document DEF.1220.0001.0071? Now, is that a document given to commanders generally across the Army? Can you see it up there?
Yes.
Yes, Commissioner.
Thank you.
Thanks. It's available on our CMA website.
Okay. Now, at page 0077, if you could go there, there's a heading mandatory issue of an involuntary cessation of service notice. When it says mandatory, does that apply to the commander or to CMA or both?
So a CO must issue an ICSIN in those circumstances.
And if it comes before the CMA, do you have a wider discretion? Can you look at it and say, well, look at the fourth dot point. The second DUI occurred 10 years after the first, and take that into account?
So, sorry, Commissioner, that's a mandatory ICSIN must be raised.
Yes.
So it's the same as a notice of positive test result to a certain degree. The notice must be raised.
I understand that.
It's not then stating that a separation will occur.
So you would have the discretion
100%.
not to issue a separation.
Yes.
Now, in exercising that discretion, let's look at the first dot point, for example, use of, involvement with or possession of prohibited substances, or the alcohol one, on the fourth dot point. Would you, in exercising your discretion, seek to speak to the person or find out from the person why they're using prohibited substances or using alcohol to a high DUI level?
Commissioner, if I can talk to the first one, the prohibited substances. So the mandatory nature of that one is because of it refers to in the Defence Act that a notice of positive test result comes in and they must be issued with an ICSIN, and then that comes into to CMA as the delegate. And as part of their statement of reasons, they can address the reasons why they have been using the prohibited substances. And in a number of the examples I've reviewed this year, they have raised that. So that is their opportunity to do that. The Chief of Army's directive also directs COs to specifically address those issues when making their recommendation to the delegate, including the members' mental health and wellbeing, any complex or significant changes to their personal circumstances.
Yes, so from our experience, it's typical of people who are suffering mental health problems
Yes.
that they may be engaging in this sort of behaviour.
Yes, I agree.
So if you do find that out, what's the range of reactions available to CMA? Can they counsel the person and perhaps delay any further disciplinary proceeding depending on the result of any treatment?
Yes, as a delegate, we can decide not to separate them, and then we can put in a range of lesser sanctions, which can include counselling, formal counselling, can include a formal warning, and it can often include the requirement for targeted testing as well, just to ensure that they don't continue to take drugs.
Now, something that doesn't appear in this list of mandatory issue of an ICSN is, for example, abuse of prescription drugs. But again, that could be something typical of somebody who's suffering psychiatric problems. If that appears as a reason profited by a commander for the separation of a soldier, would something like the process you described also apply there?
Yes, Commissioner.
I would also just note, Commissioner, sorry, that the prescription drugs are classified under the prohibited substances in terms of that all-encompassing. And just to clarify as well, that top point for a mandatory ICSIN doesn't necessarily is not necessarily resulted from a notice of positive test result. It will be perhaps they haven't got a notice of positive test result, but they have been caught with possession or civilian police have identified them as involvement with or anything else like that. So that may not necessarily linked to the act. It may well be void of the act and notice of positive test result.
Now, say you have somebody who presents to you with a couple of DUIs. Do you have the facility to interrogate your own database of decisions about how such a person in the past might have been treated?
You're talking about
within CMA?
You're talking about consistency of decision, yes. Commissioner?
Yes.
So I suppose the answer is yes to a point. In terms of once again, in terms of the system, but it also in terms of the single prohibited substance coordinator that we have, who provides the subject matter expertise and the advice and recommendations to the delegate. Sorry, did you have anything else? Did that answer the question, Commissioner?
It does to some extent. I'm wondering how well organised the database might be, because I'm coming from a background where I'm used to seeing, in a criminal context, comparable sentences, so you can get a bit of a feel for how like circumstances should be treated alike and to make decisions consistent.
So similar to the previous answers about 24-1 Charlie, is we use in the main the one delegate, which at the moment is the boss, who can then be the catch-all of that consistency. In terms of
over a 2-year period when
correct.
When one of you is in place.
Yeah. Sorry, the decision is recorded on our databases as well. Yes.
So we have a SharePoint site which records the process, where it is in the process and the decision that was made, but we have different databases for everything. We don't have a single HR system yet.
So it's a bit difficult to achieve consistency, could I?
It's difficult to achieve recording because I think we've got limitations in our HRIS system.
Right. But you have a lawyer within the CMA who can advise about legal issues. Is the lawyer someone who's been there for a significant period?
They'll also post as well, Commissioner.
Sorry?
They'll also post as well every 2-3 years.
Okay.
I would add, Commissioner, as well, that there's more of prevalence for the units and unit COs to seek assistance for those members that have been flagged already. So we talked about the vulnerability and the linkages between prohibited substances, alcohol, mental health, other issues. We've got quite a number where we see that the CO has then sought through the medical system for private facilities, private clinics. There's alcohol programs within defence. Do we enable our people to go and seek assistance through? So the decisions and the actions based off those also then add to the decision-making process.
Right.
Because you can imagine if someone refused to go to a facility and seek assistance versus someone who voluntarily goes and says, I actually want assistance, that may or may not assist with the decision-making process of retention versus separation.
Thanks. The last thing I wanted to ask about was a recommendation made to us earlier this week by Judge Douglas Humphreys, who's had a long period both in the military and as a military lawyer, and he recommended that there should be an administrative appeal on the merits available from CMA to, for example, the Administrative Appeals Tribunal, so that there could be a merits review of decisions made within your organisation about principally separation of people. Do you have any comments on that?
Is that sort of separate to IJDF? Was his concern more about IJDF make a recommendation that's not binding?
He had the view that the review by IGADF was more limited than a merits review. Similarly, that's via a redress of grievance. And his recommendation was that there should be a simple, cheap mechanism of review on the merits, not just on the legalities of a decision. Do you have any view about that?
I think if it was considered to be a way to make the system more robust without placing more pressure on the member or delaying the issue, if it makes the system more robust and more transparent, I can't see why that would hurt.
All right. Any comments?
No, I agree with the boss, Commissioner, in terms of I understand the IJDF look at more procedure rather than merit necessarily, as in was the decision the correct one, I think is what you're alluding to.
I am, yes.
So, I mean, an assessment of that would, as the boss said though, as long as it then doesn't add 3 months to the process, which will then add stress and anxiety to the member, still not knowing whether they're in or out.
Thanks.
Thank you. I'll just have a couple of issues, and I'm conscious of the time. We have a 2-hour cut-off point for the transcribing people. I think we're just going to go slightly over. I'm hoping that's okay. And I'll just preface everything I'm saying, reiterating what Commissioner Brown said. None of this is a criticism of you at all. You've inherited this system. You didn't invent it. You've walked into it. I just want to understand, and I may have this wrong, we didn't talk about any complaints that may have resulted in someone being dismissed that may have come through the IG strand. Is that a totally different track that's nothing to do with CMA? Say IG do an inquiry and they decide that Officer X should be dismissed. Would it come to you, or is that a separate, different track?
Thanks, Commissioner. So I think what you're asking is IJDF review a case, review a ROG that's been put in,
Or do their own, under their own initiative, do an investigation into someone?
and they find that that there was a flaw in the process and the member actually shouldn't have been separated.
No, I'm saying if they hear things, they have hearings and they do their own investigation, often under their own initiative. If they find someone has been guilty of something and a decision is made that he ought to be dismissed, do their decisions come to you to go through the same track, or is there a completely different track for those that the IGADF may recommend dismissal of?
I haven't seen anything like that this year, Commissioner.
So the IGADF don't recommend dismissals?
Not that I have seen this year. My only engagement with IJDF this year has been about 2 cases where they recommended that the members be retained.
I appreciate that. I'm sorry, you may not be able to answer, but is there anybody else within the Australian Defence Force, any other track through which people can be dismissed?
Yes.
Yes, through the DFDA, so that if Defence Force Discipline Act, if they go to a Defence Magistrates trial or...
Which is a completely different process that you're not involved in.
Yes, that's right, Commissioner.
Okay.
Yeah.
To clarify, Commissioner, the only involvement we have is then the administrative at the end of that process.
Okay,
No
thank you.
delegation involvement.
Okay. In the process, the delegates, is there any obligation on the delegates to do a declaration that they are not involved or know or have been close to the CEO or the person complained of? Anything that may cause them to be recused from the decision making?
Nothing in writing.
Nothing in writing.
Nothing in writing?
No.
Nothing in writing, but once again, it is the good decision making manual or the policy we have states that you must declare bias and remove yourself from it.
Yep.
Okay, I just want to go back to the quality assurance aspect. So if I've have had a complaint against me and it's sustained, I end up lodging a redress of grievance and it goes to the Inspector General. There's no record kept of the decisions that may have been overturned by delegates. The delegates' decisions being overturned, there's no analysis of trends in terms of, has there been 10 decisions of this delegate that have been overturned? There isn't.
No, there isn't, and no, not over time. I guess we're there for 2 years, so I guess it would look different over time because the delegates change. But do we track how often IJDF make an adverse finding against one of our... No, we don't.
Okay, and in terms of complaints analysis, in terms of somebody, perhaps a CEO who was lodged over the last 3 or 4 years, launched 10 dismissal processes against people, there's no analysis of any redress of grievance against an individual officer? Does anyone add them up and say, this person has had 10 redress of grievances lodged against him or her?
That would be a question for IJDF who monitor the redress of grievances.
Yeah.
Okay. One other thing. So if I have had a complaint against me, or the CEO initiates the paperwork, it goes through the process, it gets to you, and you decide you agree with the CEO and that person needs to be sacked, and I want to lodge a redress of grievance, it goes back to the same CEO?
Correct.
So I complain about my boss, and my complaint against my boss goes back to the boss.
So
And that's in the CALM, which is the Complaint and Resolution Manual. That is the process, and I think the catch-all for that is whether the CEO decides to uphold it or not, is that also goes to IJDF, and that they then review it independently. But yes.
But in the first place, it actually goes back to the person who made a decision that I'm complaining about.
So it can be very difficult for a member to pursue that action.
So, Commissioner, I would add that if you've made a formal complaint against the individual being the CEO, the process would then look at that and would be then seeking someone else to then initiate a Nixon.
I wasn't talking about a separate complaint against the CEO, a disputing of the decisions that the CEO made in initiating the sacking process.
That is the current process.
Yeah, it goes back to the same person.
Correct.
Yep.
Okay. I know we mentioned a bit earlier that you essentially, it says that we don't want you to waste time telling us about your career. We've certainly heard evidence that the HR or personnel records are often inaccurate or incomplete. Is that something that has come up where people were encouraged not to go over their career or their achievements and then found out later on, perhaps, I guess there's no way to find out whether your records were complete, let alone were in fact considered and taken into account?
Yeah, Commissioner, I can only talk about the purpose of that comment. The purpose of the comment was, in your statement of reasons, some people will write 50 pages, and out of that 50 pages, maybe half a page is actually relevant to the ICSIN that has been raised. So I think the purpose of the statement was, don't waste 50 pages, write me 50 pages on the reason why the CO has initiated a separation notice on you. Don't waste 50 pages on all of the other stuff. Concentrate on 50 pages worth of good stuff that is providing me evidence as to there's a reason why we should look at this.
Okay, and then perhaps just the final thing, the absence of face-to-face contact with the person complained of. Do you not feel that it's difficult to actually assess someone if no one's ever set eyes on them or spoken to them? Is that ever discussed, that it could be changed?
It is tough, Commissioner, and I think it's about sort of trying to be objective and trying to sort of not have that personal interaction or any emotion involved in it. And we really do rely on the statement of reasons. How we get around that, is it appropriate for the delegate to interview the member? I'm not sure. I don't have a suggestion on that. It would certainly require more delegates in CMA.
And if I could just make one other comment in relation to the guidance document that was shown earlier, and I think you mentioned, Lieutenant Colonel, that you would be happy to see it changed. Bits of it were not quite right. People do rely on it, obviously. If there are things in there, I would hope that it gets the attention and whatever inaccuracies. I know you said it's not a policy document, it's a guidance document, but that is what people were relying on. I suspect that most people would not necessarily go to the source of the policy document. They'll just read the guidance paper that they've been given. So I'd suggest that needs urgent attention if you think there's anything in there that's not quite right.
Yeah, tracking, Commissioner, and absolutely, it has been ongoing for 2 months, and I would suggest it's 95%. I would suggest by the end of next week it'll be 100%.
Thank you. Mr. Fordham, any questions?
No, thank you.
Ms. Rubigotti, any matters arising?
Arising, thank you.
Okay, may they be excused from their summons?
Yes.
Thank you for your evidence. We do appreciate it, and we appreciate the amount of effort, obviously, that went into the preparation of the material that we're relying on. We appreciate it. Okay, if there's no other matters, we'll adjourn till tomorrow morning, I think. You're excused from your summons to appear as well.
Thanks, Commissioner.
Is it 9?
Nothing further arising. What time are we starting tomorrow?
It's 9 a.m. tomorrow.
I believe it's 8:30.
Okay.
According to my timetable, but if I'm wrong, please let me know.
Excuse me for one moment, we'll just check. Yeah. Our papers say 9 a.m. We just reserve the right to change it.
We'll clarify that.
Okay. Thank you. We'll adjourn until tomorrow.
Reserve the right to change it and not tell you too.
All rise. The Royal Commission into Defence and Veterans Suicide will adjourn to 9 a.m. Thursday, 31st of August.